Today is not the mentioning date. Unless until it is extremely urgent that you cannot wait till coming Sunday, then you can mention. Otherwise, mention on Monday. Yes, call the list.
Item number 1.
Item 1, the petitioner.
Amendment.
The omission. কার্তিক দত্ত না?
হ্যাঁ, নামটা
ছিল
ছিল, হ্যাঁ।
ক্লেম হলো এখন on 1st December 2025. So, though it was dictated, thereby granting leave to the learned advocate representing the petitioners to amend the cost title for expunging petitioner number 10 from array of writ petitioners. Inadvertently, same was not transcribed in the order dated 1st December 2025. However, having heard the order dictated in open court, learned advocate representing the petitioners amended the cost title on 1st December 2025 and expunged respondent number writ petitioner number 10 from array of writ petitioners. Stop. Next paragraph. Court finds order dated 1st December 2025 requires correction. Stop. After the last paragraph in the second page of the said order, that is paragraph 7, following paragraphs are to be inserted. Stop. Next paragraph. এটা কোট আনকোট করে দেবে। Department is directed to incorporate necessary corrections in the order dated 1st December 2025. Stop. This order forms part of the order dated 1st December 2025. ঠিক আছে?
Grateful, my lord. Much obliged. Item number 2.
Yes. Why?
Mr. Bhutia sir has secretly on the way.
Never he appears.
My lord, he's on his legs, my lord. So we have already received the instruction, my lord, from the minister, my lord. He's on his legs, my lord. Just praying for short Passover for 15 minutes, my lord.
The order was part of this photo card. Let's do it. Now he is procedural.
We have already communicated the order, and here is the affidavit of service. We have communicated the respondents, added them, we have done it.
We'll pass over, short pass over.
Obliged, my lord.
Ask Mr. Jha to immediately come.
Yes, your lord.
Item number 3.
I appear for the respondents, all the respondents.
Appear on behalf of the petitioner, my lord. Beg to appear on behalf of the petitioner, my lord.
Yes, have you deposited deficit
No,
code?
my lord, kindly give some time, my lord. By this week, I will deposit the.
Why not? It was not
My lord.
deposited. Order was passed on 19 November. By 7 days, it was directed to be deposited.
2 days, my lord. I'll deposit the entire court fees, my lord. Thank you, my lord.
Issue. At the time of call, learned advocate representing the petitioners has prayed for extension of time to deposit deficit court fees. However, next paragraph, however, respondents are represented by learned advocates. Next paragraph. Time to deposit deficit court fees stands extended by 7 days. Stop. List the matter under the same head. List the matter under the head. List the matter under the heading motion in the monthly combined list of January 2026. Great. ওটাকে করে দাও ডিপোজিটের টাইমটা ফর্টনাইট করে দাও।
Item number 4.
I am appearing for the bank, my lord, kindly praying for a Passover, my lord. Is Aprajita Rao is court number 39.
You are for the bank authority.
My lord, I am for the petitioner.
For the bank, my lord, Miss Aprajita Rao is engaged in court number 39, my lord, kindly keep it Passover, my lord.
Yes.
I am praying for Passover, short Passover, my
No,
lord.
all matters cannot be passed over in this fashion. Sorry. Court does not sit at 10:30 to make the matters passed over. Yes, what is the matter about?
My lord, I am for the petitioner. When I was posted as a bank manager in Khidirpur branch, then at that time I have given home loans as per the bank's direction. But some of the home loans means they have been bounced. Okay. And some of the
Don't
promoters.
say okay before the court.
What?
Don't say okay before the court.
I am apologize, my lord.
It is not your drawing room.
Apologize.
Yes.
My lord, some of the loans has been bounced. When I reported to the bank the matter, then bank set up an inquiry. And in that inquiry, though I have given my means defenses that, but still the bank has suspended me and bank has removed me from the service. Not only bank has removed me, also my assistant manager has been removed. But in the
Assistant
same
manager has been removed means I couldn't follow.
my lord, two managers has been removed. One was me, the petitioner Sudipto Bhomik.
So are you challenging the order of removal? or
Yes, order
dismissal?
of removal, order of
Where is
dismissal.
the order of removal?
My lord, it is at page number 507. The photocopy of the administrative order 111/2024 dismissing the petitioner from service.
#507 1st November 2024.
Yes.
Just a minute. Against that, you preferred appeal. Is there any provision
Yes, my
for
lord. I
departmental
have
appeal?
preferred appeal against that. And the order of the final appellate authority is at annexure P9, page number 530 to 613.
Order of the disciplinary authority was affirmed by the order of the appellate
Yes,
authority.
my lord.
There is no further forum.
No, my lord. No further forum is there.
Challenging the order of the disciplinary authority and the appellate authority, you have approached this court.
Yes, my lord.
But it appears that all the pages of appellate authority is not there. Come to page 5, last page of the writ petition 535. Charge number 6 was discussed, but there is no other page. 53, come to page 535. This is the last page of, oh, there's a further volume.
Yes, my lord.
Where is the concluding part of order of the appellate authority? Concluding page
It is at 613.
613.
613, page number 613.
Concluding page of the order of the appellate authority. Last page of order of the appellate authority.
It is at 613. It is with the
Thus, in view of the foregoing proven facts, 1 3 it ends.
with the heading that hence the appeal does not have valid ground and merit to give the appellate any relief.
No, it starts from page 530.
Yes, my lord.
And-
Next volume,
And yes, next volume, where is the last page of the order of the appellate authority?
613.
starts and ends at 613.
Now, what interim order you are praying for?
My lord, I
There is
am
no scope for any interim order.
my lord, I am challenging the entire proceeding of this
Yes,
disciplinary
there
authority
is no
and
scope
appellate
for any
authority.
interim order. You have challenging the entire proceeding as well as
My
the
lord,
order of the disciplinary authority
my
and
lord,
the appellate
My lord,
authority.
my ground for challenge is that if you please come at paragraph number 9, if you in that paragraph I have clearly mentioned that there is an instruction circular by the bank 2648 file number 24 dated 15/5/2025, and it is at annexure P11 pages 631 to 648. If you go by this instruction circular, you will see, my lord, that the loan that I am giving, okay, that has to go through multiple proceedings like RPC, that is RAC, then CPAC. Multiple authorities are
So
over
it
me.
is to be decided on exchange of affidavits. At this stage, there is no scope. What interim order court will pass? Esho. File your affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Please reserve your energy for the final hearing.
The modified cost title has not been served. So if at all we need to apply for certified copy also, we will not get.
Have you? Why
I
it
have,
has
I
not
have
been
served it,
served?
my lord. This is my affidavit of service based on Regional Head Central Bank of India modified cost title.
Cost title, you have to serve the copy of the cost title, amended cost title upon the learned advocate representing the bank authority.
We need certified copy,
Okay.
we can apply.
You give me your number, give me some time, I will serve it.
Yes, yes, I will.
In the writ petition order of the disciplinary authority dated 1st November 2024 is questioned whereby petitioner was dismissed from service with future disqualification with disqualification for future employment. Top. A departmental appeal was preferred. And the appellate authority video order dated 5th May 2025 affirmed the dismissal order passed by the disciplinary authority. Next paragraph. There is no scope for passing interim order. Stop. Validity and legality of the impugned orders passed by the disciplinary authority and appellate authority are required to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 1 week after ensuing Christmas vacation. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next paragraph. Since cost title of the writ petition was amended in terms of the order dated
98304.
26 November 2025, learned advocate representing the petitioner is directed to serve amended cost title upon the learned advocate representing the bank authority by 5th December 2025.
And only one point, if I may just say, my lord, he has not approached the review committee. That is as per our guidelines, my lord. He could have approached review committee.
Oh, there is a provision for review.
Page number 46. There is a review. He has not approached for review committee. If my lord.
Why I have asked you that, is there any further forum?
Yes.
You have said, no, there is no further forum.
Volume 1,
My
page
lord,
46.
at the time,
What sort of advocacy is this? Is it the way you will assist the court?
my lord, if I approach the review committee, the order will be the same because
This is the answer. When court has specifically asked you whether there is a
my lord,
provision for
they are
review
not,
or not,
they are not hearing me.
you could
That
have said so that I don't expect that there is any change in change in situation if review is preferred, but there is a provision for review. The junior member of the bar, you are misleading the court.
my lord, I tender my unconditional apology that somehow I have missed the point.
This is
That
the
I-
way to present the case. When court has specifically asked you, then is there any further forum challenging the order of the appellate authority? And you have said no further forum. Be candid before the court, because clients will come and go, but you will be here for rest of your life,
Yes, my lord.
and court will gather a wrong impression that you do not tell correct situation while presenting your case. After see the inconvenience which you have caused to this court. I have dictated the order. Now it is coming that there is an review provision. Unnecessarily wastage of time. Now, if I impose a cost of 10,000 rupees for wasting judicial time, who will pay? You or your client?
My lord, please don't pass such a harsh order. I tender unconditional apology. And my lord, I haven't approached the review committee because if
Issue.
Page 46, my lord.
Yes, where is the provision for review, Ms. Rao?
Page 46. Page 46, volume 1. Clause 18.
Still বলো তো। জিজ্ঞেস করলাম specific. This is the rules relating to.
My lord, it starts
Very-
from page 30. Central Bank of India Officers, Employees, Discipline and Appeal Regulation 76.
It starts from which page?
30.
30.
my lord,
Please wait. Enough is enough. Please take your seat. So there is a time of 6 months.
Yes.
Then the appellate authority's order is
That's
May
May.
2025.
Yes.
May 2025 order. Just
Yes.
15th May to 5th May 2025. June, July, August, September, October, November.
And this writ petition was filed, my lord. At least the date which has been given in the affirmation is, my lord.
So let me direct the petitioner to prefer a review within fortnight from date.
Yes, my lord. Because
And if that is carried out, in that event, without raising the point of,
yes, of course.
because 6 months has
Of course,
already
my lord.
passed.
Of course, ma'am.
6 months has already is over. So therefore, today this order is dated 5th of May 2025. Now, if you count 6 months, then June, July, August, September, October, November, it has ended.
My lord. My
Now,
lord,
petitioner has filed a
this November date.
petitioner has filed a writ petition on 7th November 2025. Within time, not within time, beyond time, because 4th of November, 6 months period has expired. So therefore, let me extend the time for some time. কি বললাম বলো তো প্রথম থেকে? Now with disqualification for future employment. ওই ফিউচারটা পরে কেটে দিয়েছিলাম ফার্স্ট ফিউচারটা। হ্যাঁ, হ্যাঁ, বাদ বাকি এটা কেটে দাও। Next paragraph. During course of hearing, Miss Rao, MS, Miss Rao, learned advocate representing the bank authority, has brought to the notice of this court the provision as contemplated under Regulation 18 of the Central Bank of India employees within bracket discipline and appeal close bracket regulations 1976. Stop. It is submitted by on behalf of the bank authority that if the delinquent employee, if the petitioner is aggrieved by the order of the appellate authority, he may prefer a review before the reviewing authority, RA capital, before the reviewing authority within the time specified therein. Stop. In next paragraph, in view of availability of alternative efficacious speedy remedy, court grants leave to the petitioner to prefer a review application before the reviewing authority in terms of Regulation 18 by fortnight from date. Stop. If within the aforesaid time review application is preferred, questioning order of the appellate authority dated 5th May 2025, the reviewing authority shall decide the review application on merit without raising point of limitation. Stop. Court also directs the reviewing authority to decide the review application by 12 weeks from the date of filing of the said application in the event review application is preferred within the time stipulated by this court. Next paragraph. Writ petition stands disposed of. Urgent xerox certificate.
Item number 5.
5 minute, I am for the petitioner. This is my affidavit of
The
service.
last of it, the lordship has granted time for instruction. My lord,
The
we have
Passover
got
matter or the
No, my lord.
this is fine.
fine?
This is fine.
May I, my lord, place my case?
Time of call accommodation has been
My lord, actually, we have been instructed to sort for
hearing of this matter stands adjourned. This matter of same meeting. Yes, place your
we have
place.
been instructed, my lord, to sort for 5 weeks time because, my lord, this relates to Jammu and Kashmir. The incident is of, so, my lord, for that, my lord,
How much time?
4 weeks time.
4 weeks.
We are asking, my lord, as per your lordship.
It is an era of information technology. By one day you can get instruction over mail or through electronic media. Very well, I am granting you 7 days time obtain instruction. Issue. At the time of call, Mr. Jha, learned advocate representing Union of India, has prayed for accommodation to obtain instructions. Stop. Acceding to the request made on behalf of Union of India, hearing of this matter stands adjourned. Stop. List the matter under the same heading for further consideration on 16th November 2020. 16 December 2025. Take it back. Affidavit service to opore kore dao. Affidavit service by the petitioner. Yes, call the Passover matter.
Passover matter, item number 2.
In this matter, it relates to the granting of height, 0.5 centimeter.
Height এটা hyper
Relates to pigmented patch.
Medical report.
yes medical they had declared fit.
Report.
Whether petitioner is dermatologically fit or not. Now there are two divergent opinions expressed by the medical experts.
Second, he obtained but
Well, their report they have declared me fit. They have examined me and they have declared me fit.
got my formal objection and passed necessary orders. And not required. Because last occasion also, the Lordship had the view, since what I have gone through, taking formal objection.
What are the reports you are relying upon?
My lord,
First is page 7.
First is page, my lord, I am coming to page number.
Supplementary affidavit is there.
No, first 31, my lord, DME. In DME, I was declared medically unfit. Hyperpigmentation patch over left eyebrow melanoma. I am just repeating, recapitulating for my lord.
Yes, yes, page 31.
31, I was declared unfit.
Melanoma.
Yes, melanoma. My lord,
Melanoma.
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 My lord, then I preferred
Pigmented patch over the left eyebrow.
eyebrow. Then I preferred an RME, review medical examination, which is the supplementary page number 6, my lord. Supplementary affidavit, page number 6. There, they took me to IQ City Hospital, where kindly takes up the supplementary affidavit once, my lord.
Yes, page 7.
Page 7. There they get me examined, where I was declared he is fit dermatologically.
Yes.
Yes, my lord. And
So that is at the instance of the
there,
respondent.
yes. This was done. Kindly see his, my lord, pair name CRPF credit on the top. My lord, kindly see his date, 8 October at the, then kindly
And
the
your
last.
DST was when it was the
Man-
first medical report was when the first petitioner was medically examined on 5th October.
October 2024.
Then on 8th October, IQ City.
IQ City. In IQ City, I went for examination of compound nevus. That was the examination. And he was fit dermatologically. Then compound nevus. And I was declared he is fit dermatologically.
Yes.
Then comes to page number 6, my lord, of
Right.
that subject. Yeah,
Hyperpigmented patch over.
that
It's
was
a review.
That was made DME. In the RME, brief of review medical examination and finding thereof. Dharma opinion, compound nevus. But that was never the thing. I was already declared fit.
Hyperpigmented patch over left. Melanoma.
আগেরটা যেখানে ও সেকেন্ড ওপিনিয়নটা করে দিয়ে ওটা কোন পেজে দেখাচ্ছে বলে তো
What is compound nevus?
My lord, as far as the medical guidelines is concerned, I have not found anything with regard to compound nevus. That is also a big my lord, question mark in that thing, my lord.
Issue. CAPFS.
CFGF, yes, my lord.
Constable GD.
Constable GD.
Matter is heard in presence of the learned advocates representing the petitioner and Union of India. Stop. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD in Central Armed Police Forces within bracket CAPFS. Stop. After being qualified in written test, written test, petitioner was medically examined. First, on 5th October 2024, and he was not declared medically fit. Stop. In medical examination report dated 5th October 2024,
এখানেও বলছে
it was reported that due to hyperpigmented patch over left eyebrow hyphen melanoma, page 31, read petition. Petitioner was declared medically unfit. Stop. Petitioner preferred review, questioning, medical report dated 5th October 2024. Stop. At the instance of, it is submitted that at the instance of concerned respondent authority, petitioner was examined by the medical experts of
IQ City Hospital.
IQ City Medical College.
Yes, ma'am.
It can't be read due to stitching of corner of the page.
My lord, IQ City Medical College Hospital.
IQ City
Medical.
IQ
Yes, ma'am. IQ.
City Medical College Hospital.
Durgapur.
Durgapur. It is at Durgapur. Medical Hall, Medical College and Hospital. On 8 October 2024, and petitioner was declared dermatologically fit. Stop. On the same date, in review medical examination, petitioner was not declared medically fit on the ground of compound nevus. COMPOUND NEVUS.
He was not asked, my lord, he was not asked to go by the department record. Kindly come to page paragraph 9. My lord, he himself went to that hospital.
Acha.
That is.
My lord, CRPF credit. It is the paper shows CRPF credit.
My
My
lord,
lord, kindly see
paragraph
the page,
9.
my lord.
Paragraph
lord,
9, my lord will see the submission what he is making.
My lord,
Please, that should not be recorded with that.
my lord, kindly
But
see.
come to page 7.
My lord,
My lord,
Payer name, who paid?
yes, my lord.
Payer name, CRPF credit. Come to page 7 of the supplementary affidavit. So therefore, the cost was borne by borne by CRPF.
but my lord has come to, my lord will see paragraph 9. my lord.
No, I will go by this page 7.
My lord, they are saying that the
If petitioner on his own went to IQ Medical City for obtaining a medical report, then question of payment by CRPF does not arise.
But my lord, paragraph 9 says so. I am saying paragraph 9 of the petition. my lord. On self same day, before going to the review medical board, the petitioner went to get himself examined at IQ City Medical College, wherein and whereby wide report MD petitioner was declared unfit after thorough examination there. Unfortunately, enough on the very similar. And nowhere he is saying that he has been asked.
My lord,
But that does not mean that he was not
But my lord,
medically examined
since-
at the instance of CRPF. It may not have been correctly drafted, but it does not mean, because the document says that PR name CRPF
I
credit.
was just pointing out that thing to you. Lordship.
Yes, yes. হ্যাঁ, কি বলছিলাম? On the ground of compound nevus. Stop. It is contended on behalf of the petitioner that as petitioner was declared dermatologically fit by the medical expert of IQ City Medical College, compound nevus ought not to be a cause to declare the petitioner medically unfit. Next paragraph, Mr. Brojesh Jha, learned advocate representing Union of India, in reference to paragraph 9 of the writ petition, has submitted that medical examination by the has submitted that medical examination to examination that examination by the medical expert of IQ City Medical College was not at the instance of CRPA. Rather, petitioner decided to get medical report from different medical expert.
My lord, that has been corrected in the supplementary affidavit, my lord. Inadvertently it has been stated. বলেছি আমি।
However, now stop. Next paragraph. Now stop the at a line. Petitioner on behalf of Union of India, prayer of the petitioner is opposed. As in review, petitioner was not declared medically fit. Next paragraph. On perusal of a document at page 7 of the supplementary affidavit affirmed by the petitioner on 2nd July 2025. It appears the submission made on behalf of respondent authorities that petitioner in his own went to IQ City Medical College for obtaining another medical report is found to be not correct, as it is stated in the medical report dated 8 October 2024 issued by the medical expert of IQ City Medical College that cost of medical examination was borne by CRPF, not by the petitioner himself, which goes to show that petitioner, at the instance of concerned respondent authority or at the instance of CRPF, was medically examined by a doctor of IQ City Medical College. Stop. Next paragraph. In addition thereto, nothing is demonstrated on behalf of the respondents that in the event it is a case of compound nevus, petitioner needs to be declared medically unfit. Moreover, as per report dated 8 October 2024 issued by the consultant dermatologist of IQ City Medical College, it was declared that petitioner was dermatologically fit. Next paragraph. In aforesaid conspectus, concerned respondent authorities are directed to treat the petitioner medically fit and consider petitioner's appointment in the post of Constable GD in CAPFS if petitioner is otherwise found to be eligible. Writ petition stands disposed of. Urgent xerox certificate copy. Judgment form में पढ़ो.
Item number 6.
My lord, I am appealing on behalf
For the petition in this
respondent,
matter,
my lord, I am raising the preliminary objection regarding the jurisdiction, my lord. Charge sheet has been issued at Jharkhand. Inquiry was held at Jharkhand. And also, my lord, the disciplinary authority at Jharkhand. Only mere presence of, my lord, appellate authority, he has filed this case here. My lord, your lordship knows that.
Now, whether the appellate authority has taken a decision.
It is an inquiry stage.
Page 77 is the answer. Petitioner is an employee of Coal India Limited, presently posted at, my lord, BCCL. Now, my lord, here, my lord, may I
tell the fact first, my lord. Here, petitioner is praying for the stay of the disciplinary proceedings initiated on the self-same issue during pendency of the CBI case.
No, court is considering the territorial
Yes,
jurisdiction of
so
this
my lord,
court.
now, as to why I'm
Because
telling.
the incident based on which charge sheet was issued took
Yes,
place
yes,
where?
I know the, my lord, I have to have.
Where it took place. Court is asking
At,
to
my
ask
lord,
to know
Jharkhand.
you know everything.
Yes,
court
yes.
knows.
At,
It is your case.
yes, my lord.
But in order to appreciate the facts,
yes, my lord,
when it took place
at Jharkhand.
at Jharkhand.
And sanction has been granted. That's why page 77 from Coal India Limited. Based on this sanction, my lord, the entire proceedings have been initiated. Page 77, if your lordship kindly come. Now, your lordship will find the relevant portion, page 79.
No, you are perhaps matter was taken up previously.
Yes.
You are questioning that due to pendency of criminal proceedings, disciplinary proceedings should be stayed.
Yes. That is the main prayer.
Now the criminal proceedings you have obtained bail.
Yes.
You have obtained a bail from a court of Jharkhand.
My lord.
Now the inquiry proceedings has started.
Started at Jharkhand.
It has started or it will start?
It has started at Jharkhand.
Jharkhand.
My lord.
So now it is confined to the inquiry to be conducted by the inquiry officer at Jharkhand.
Jharkhand.
Now criminal proceedings
Jharkhand.
Also pending.
Everything is Jharkhand.
Jharkhand. So approach the Jharkhand High Court.
My page 70. That's why I am telling you, page 77.
Today court is not considering the appeal.
No.
Sanction.
No.
Whether the inquiry is to be proceeded with or not.
That's why, my lord, I am telling.
Inquiry is to be proceeded with or not. Now your contention is this, Mr. Ghosh, that if you disclose your defense,
my lord,
in the inquiry proceedings, then your right to defend yourself in criminal proceedings should be prejudiced.
Now
the criminal proceeding is continuing in Jharkhand and the inquiry proceedings is scheduled to continue in Jharkhand.
Now,
so therefore, it will be improper to entertain this writ petition here at Kolkata.
Well, as to why I am telling, my lord, page 77, this is the sanction granted by the, my lord, Coal India Limited from here.
What sanction has been granted?
Sanction for, my lord, disciplinary proceedings and, my lord, the criminal proceedings.
To initiate the disciplinary proceedings. Yes, this sanction has been granted here at Kolkata.
My lord, page 79, kindly come.
But today court is not considering the entire gamut of the disciplinary proceedings. Only thing is whether the inquiry is to be continued during the pendency of the criminal proceeding or not.
My lord, I will, my lord, so to your lordship on judgment of, my lord, the Eastern Coalfield, my lord. They carried to, my lord, Supreme Court. I will coming before that, my lord, kindly come page 79, my lord. Because I am an employee of Coal India Limited. Paragraph 3 from top. Based on this document, my lord, the disciplinary proceedings shall be. Paragraph 3 from the top.
Paragraph 3 from page 80.
Page 79, my lord.
79.
My lord. The chairman come managing director, Coal India Limited, kindly read, my lord.
Now, chairman cum managing director has approved it.
Yes. So
He is, yes,
he's here.
he has approved it to initiate criminal proceedings under section 7 of the Prevention of Corruption Act as well as disciplinary
Proceedings.
Now, your contention is this is confined to inquiry proceedings.
My
That
lord.
if inquiry is conducted,
My lord.
in that event, you will be prejudiced in the criminal proceedings. That inquiry, disciplinary proceedings will come later.
My lord.
That inquiry is to be conducted by an officer at Jharkhand.
My lord.
And the inquiry is to be conducted at Jharkhand.
My lord.
Incident took place at Jharkhand.
My lord.
Now the court where criminal proceeding is pending is also before the Jharkhand.
Yes.
Before Jharkhand.
My lord.
So therefore, if this matter today, suppose I, after hearing you, as I have done in other two matters, you
My lord.
move this petitions, I state
My lord.
the inquiry
My
proceedings
lord.
in view of pendency of the criminal proceedings.
My lord.
If it is done here and the criminal proceeding is pending at Jharkhand, there will be difficulty.
Well, that matter also criminal proceeding pending at Jharkhand. That matter will also state.
Yes,
So, my
yes,
lord,
this point was not taken. I have passed a wrong order.
no, because inquiry was conducting here. That matter is something different.
Yes,
Inquiry
that's
is
why I
that's
passed
why
order.
you passed the
Because
order.
there was an inquiry was, yes, now I remember it was at Kolkata. Inquiry
Kolkata.
was
At
scheduled to-
Asansol, my lord. So, my lord, here,
it is, Mr. Ghosh, it is related to your inquiry.
my lord. Now, Kali come my
Now,
prayer. my
now when the part to be played by the disciplinary authority, after the inquiry, this report is to be supplied to the delinquent, that is petitioner. Petitioner will respond to this inquiry report, then second show cause notice, reply, then entire materials will be placed before the disciplinary authority. Disciplinary authority will pass a final order. Now that stage has not reached. Here only thing, if inquiry is over, you would not have approached this court.
My lord.
But since it is completely related to inquiry, and inquiry is scheduled at Jharkhand,
My lord.
now you should move Jharkhand High Court.
My lord, here, my lord, if you also Kali come page, my prayer A, my lord. Prayer A.
Your contention, Mr. Ghosh, is this, that this chairman cum managing director is the authority to
Authority.
approve, to has given approval to initiate proceedings.
Yes.
Criminal proceedings as well as disciplinary
What the
proceedings.
part cause of action?
Whose seat is at here at Kolkata.
Kolkata.
So therefore, there is a part cause of action
My
under
lord.
Article 226(2) of the Constitution of
My
India.
lord.
But it is completely confined to inquiry.
Now, my lord, may I show one judgment, my lord? Wait, wait. This is a Supreme Court judgment, Eastern Coalfield versus, my lord, page 82, my lord, if your lordships kindly come. This is a report in 2008, volume 3, SCC, page 456.
Page 82.
Page 82, my lord. My lord, here, my lord, the similar question arose. Now, Supreme Court, my lord, Honorable Supreme Court declined to entertain, my lord, the writ application at Kolkata on the reason, my lord, paragraph 5, if your lordships kindly come. Similar issue, my lord. Mr. Anif Saj, the learned counsel appearing on behalf of the appellant, that appellant is Eastern Coalfield Limited, submitted that it is not a case where sanction of the corporate office or head office was required to be taken. The entire cause of action having arisen within the jurisdiction of Jharkhand High Court, the Calcutta High Court could not have exercised any jurisdiction in the matter. So, my lord, sanction, when the sanction is here, the part cause of action is here, my lord.
Mother, kindly say the paragraph.
Just a minute.
Right? Only the court will have the jurisdiction which is the entire cause of action.
Paragraph কত বলছে? Paragraph কত?
Paragraph 12.
ওইটাই, ওইটাই।
SSC 456 এটাই বলে। And out of the
It is answered in paragraph 13.
13.
Come to paragraph 13, Mr. Ghosh,
My lord.
and place that paragraph. Page 87 of your compilation.
My lord.
we are of the opinion only because
In view of the decision, not opinion.
That the entire cause of action arose in Mugma.
In view of the decision of the Division Bench of Calcutta High Court,
we are of the opinion that
Yes.
only because
So,
the head
my lord,
office of the
here,
that just a minute,
Ma-
that the entire cause of action arose in Mugma area within the state of
Jharkhand.
Jharkhand. We are of the opinion that only because head office of the appellant company was situated in the state of West Bengal, the same by itself will confer any jurisdiction upon the Calcutta High Court.
That's why,
Particularly when the head office had nothing to do with the order of punishment passed against the respondent.
well, that's why paragraph 5 I have shown to your lordships. Sanction was granted from here. Here, my lord, on the facts, Paragraph 5, if your lordships kindly come, page 85. Mr. Onif Sajde, learned counsel appearing on behalf of the appellant. Appellant means Eastern Coalfield. Submitted that it is not a case where the sanction of the corporate office or head office was required to be taken. Here, my lord, sanction was required to be taken. That's why sanction. That under that fact
Come to
only.
paragraph 8.
8.
Kusum ignorance was considered,
Yes.
where it is stated that the question to some extent was considered by three-judge bench of this court in Kusum ignorance ignorance alloys limited versus Union of India.
My lord.
Now in Kusum ingots, it is stated that the facts pleaded in the writ petition must have a nexus on the basis wherever prayer can be granted.
Yes.
Those facts which have nothing to do with the prayer made therein cannot be said to give rise to a cause of action which would confer jurisdiction on the court.
And here, my lord, I have, my lord, the issue.
Here, that is what I am discussing.
My lord.
That here you are praying for basically stay of inquiry.
Basically,
Why? If inquiry is conducted, you are required to disclose your all cards,
my lord.
all evidence,
Yes, yes.
all evidence.
Now, my lord, if your lordships
That
kindly-
would prejudice
my
you
lord.
in the criminal proceedings which is pending before a court at Jharkhand.
Jharkhand. Now, my lord, if your lordships kindly come another judgment, I have made some compilations, my lord, if your lordships kindly allow.
No further compilation is necessary. Where at the
Only one judgment, my lord. Kindly,
yes,
my lord.
where is the charge sheet and inquiry notice?
No, only one judgment, my lord. Division bench judgment of this honorable court, my lord.
I have considered Supreme Court judgment.
Page
Yes.
46, my lord. Charge sheet.
Charge sheet is page 46, my lord.
46. Kindly see bottom portion, registered office, Koila Bhavan, Koila Nagar, Dhanbad.
No, all are, my lord, that Jharkhand, my lord. I am admitting, my lord. Charge sheet, inquiry, reply, everything is Jharkhand,
Is going
except
on.
that, my lord, sanction.
And inquiry has not yet been concluded. That is different. And CBI is concerned, my lord, it is also kindly come.
Now it is stated that this was issued from Jharkhand.
Yes,
Yes.
everything
Where
is
it is
Jharkhand.
stated, page 46.
Page
Office
46,
Page
my lord.
46, bottom portion, my lord. Registered office, Koila Bhavan.
Yes,
But
and then the inquiry
inquiry, my lord, he has not annexed, my lord, inquiry is going
inquiry notice.
No, I have annexed, my lord, inquiry notice.
on. Inquiry notice.
That
my
is
lord,
at page, my lord, 88.
88.
88.
Inquiry proceedings.
No, admittedly, it is Jharkhand, my lord, Dhanbad.
And also.
I require these facts.
Yes, yes, my lord.
and
Page
page
86,
61
88.
Also CBI, my lord. CBI has given notice at
Just a minute, one after another. Let me make a note of it.
page 61.
Page 84, my lord.
Where is the first inquiry notice?
Page 84, my lord. Your lords will find at bottom, my lord. Koila Bhavan, Jharkhand. At
Chairman
bottom.
cum managing director. Yes, sir.
Register office, Koila Bhavan.
It is from Dhanbad.
And
Yes, yes, Dhanbad.
my lord,
This is the inquiry notice, page 84.
This is, my lord, the appointment of the inquiry officer, my lord.
appointment of the inquiry officer. And page 61, my lord, Subhadra.
Just a minute. The points presenting officer. Inquiry officer. Yes, then in first inquiry notice, page 88.
Page, no, first order, my lord, 86.
86 and then 80.
Already it has started.
Yes, already
It
started.
has commenced.
Commenced. And my lord, kindly come to page 61.
And when the next date of inquiry is fixed, it was scheduled on 10th October 2025.
Going on, my lord, the next date,
And the next date fixed on?
it is not known to my applicant. And my lord, so far the criminal case.
Petitioner very well know, and because petitioner got
No. And the criminal case?
Criminal case at page 61, my lord, it has.
Page 51.
61. According the final report under section 173 of the CRPC charge sheet in connection with CBI case, Superintendent of Police, CBI, ACB Dhanbad.
So. No, this was issued by the Superintendent of Police, CBI, ACB Dhanbad. Now the issue is pending, case is pending before which court? CBI court.
at Dhanbad, my lord.
Special Judge, CBI cases, Dhanbad.
In the Court of Special Judge, CBI cases, Dhanbad, page 63.
But I was under the impression that the chairman come managing director is stationed at Kolkata. That is not fact. That is not the fact. It is stated page 79, Mr. You are relying upon page 79, and whereas chairman come managing director Coal India Limited being the authority competent to remove said remove the petitioner who was serving as colliery engineer. So chairman can managing director Coal India Limited being the authority competent to remove. And this office order was issued by the chairman and managing director discipline authority. Is not the same authority.
No,
Actually, my lord, chairman.
Authority is Coal India Limited. Now the.
No, actually, disciplinary authority is my lord, chairman Coal India. They have delegated. No, they have delegated to the my lord chairman the BCCL authority. That's why this sanction letter was issued by them.
He is a my lord, employee of BCCL.
No, I am an employee of Coal India. I have been posted at BCCL.
Now the. The jurisdiction will.
Just a minute. Issue. Petitioner, affidavit service, file your affidavit service. Affidavit service filed on behalf of the petitioner is taken.
Last day I filed, madam. Last day I filed.
It is already
It
filed.
is already on record, madam.
A matter is heard in presence of the learned advocates representing the petitioner and Coal India Limited. And Coal India Limited.
Both, all the respondents.
Petitioner and the petitioners and the respondents. Stop. A case is made out on behalf of the petitioner that initiation of disciplinary proceeding charge sheet dated 1st April 2025.
Yes.
Initiation of disciplinary proceedings based on charge sheet dated 1st April 2025 against him would be fatal in view of pendency of criminal proceeding before Special Judge CBI cases Dhanbad under Section 7 of Prevention of Corruption Act 1988. Stop. It is agitated that if defense is disclosed in connection with if defense is disclosed in inquiry proceeding in connection with disciplinary proceeding, or if defense is disclosed in the inquiry in connection with disciplinary proceeding, petitioner would be prejudiced in defending himself in the criminal proceeding pending before CBI court or pending before Special Judge CBI cases Dhanbad. Prayer is made to stay disciplinary proceeding / inquiry proceeding, which is continuing against him. In order to refute the submission made on behalf of respondent authorities that this court does not have territorial jurisdiction to entertain this writ petition, learned advocate representing the petitioner has placed reliance on the judgment of the Honorable Supreme Court reported in 2008 3 SCC 456 within bracket Eastern Coalfields Limited and others versus Kollan Banerjee. Bracket close. Next paragraph. It is submitted on behalf of the respondents that this court may not have territorial jurisdiction to entertain this writ petition, since charge sheet dated 1st April 2025 was issued by the chairman cum managing director, being the disciplinary authority whose office situates at Dhanbad, comma, office order dated 22nd September 2025 was issued by the disciplinary authority appointing inquiry officer and presenting officer, and both the officials are functioning at Dhanbad, and inquiry is conducted at Dhanbad. এর আগে ও যেখানে শেষ করলো, লাস্টে একটা প্যারাগ্রাফ দিয়ে দাও, যে পয়েন্টটাও নিয়েছে বলে দেওয়া ভালো। Reliance is also placed, ওই আগের প্যারাগ্রাফের লাস্ট লাইন, also placed on sanction order dated 26 November 2024 issued by chief manager within bracket personnel, chief manager within bracket personnel close bracket Coal India Limited, in order to content that as formal approval is granted by the said chief manager within bracket personnel whose office is at Kolkata to initiate disciplinary proceeding and criminal proceeding against the petitioner. Part cause of action arose within the jurisdiction of this court. তারপরে ওর submission. Next paragraph. Though it is submitted on behalf of the petitioner in reference to paragraph 5 of Kullan Banerjee Supra, that the case which was considered, that the issue which was considered by the Supreme Court was based on fact where sanction of the corporate office or head office was not required to be granted. But in the present case, such sanction has been accorded by the chief manager personnel who functions at Kolkata. Therefore, according to the petitioner, ratio of Kullan Banerjee Supra may not be applicable in the present case. Stop. However, taking note of the relevant facts and the prayer couched in the writ petition, this court finds it apt to deal with those facts as it is tried that in the matter of to deal with these facts as it is tried to deal with these facts in order to come to a conclusion whether present court has territorial jurisdiction to entertain this writ petition or not. Basically, prayer is confined to stay inquiry proceeding which is contemplated against which has already been initiated against the petitioner based on charge sheet dated 1st April 2025 issued by the disciplinary authority from Dhanbad, Jharkhand. The reason to stay the reason to make a prayer to stay the inquiry proceeding is continuation of disciplinary proceeding is continuation of criminal proceeding under Prevention of Corruption Act 1988 before Special Judge, CBI cases Dhanbad. According to the petitioners, if defense is disclosed in inquiry in connection with disciplinary proceeding prior to conclusion of criminal proceeding, that will prejudice him to defend his case before the criminal court. Stop. Therefore, entire issue is at present restricted to the criminal proceeding which is pending before Special Judge CBI cases Dhanbad, Koa DCP Koa inquiry proceeding which is pending before the inquiry officer who is conducting such inquiry at Dhanbad. Stop. Formal approval granted by Chief Manager within bracket Personal Coal India Limited as contained in sanction order dated 26 December 2024 is immaterial in order to adjudicate the issue involved in this writ petition. As such, question of arising part cause of action within the jurisdiction of this court does not arise. Next paragraph. In Kullan Banerjee Supra, Honorable Supreme Court relied upon relevant part of Kusum Ingots and Alloys Limited versus Union of India, reported in 2004, volume 6, SCC 254, wherein in paragraph 18, it was observed as follows. এইটাকে ইয়ে করে দেবেন, page 86 of compilation. Stop. In view of paragraph 18 of Kusum Ingots Supra, as considered in Kullan Banerjee Supra, this court is required to consider the prayer based on the facts of this case কি বলছিলাম সেন্টেন্সটা based on relevant facts only as narrated in the writ petition, not on other facts which has no nexus with the relief sought for in the writ petition. Stop. It is already been discussed above that formal approval accorded via a sanction order dated 26 December 2024 issued by Chief Manager Personnel is not a relevant fact in deciding the lease. Stop. Next paragraph. As it is found that inquiry is being conducted at Jharkhand and criminal proceeding is also pending before a court at Jharkhand and charge sheet was issued also from Jharkhand, this court does not have territorial jurisdiction to entertain this writ petition. Stop. Hence, writ petition stands dismissed. However, this order shall not preclude the petitioner to approach the appropriate forum in pursuit of his remedy.
Get to it.
I am keeping your compilation after
Yes,
putting
yes,
signature,
yes.
you will get
Yes,
it.
ma'am.
You will get it back because I know that this compilation is used by you in very many matters. Yes.
No, it's for the court, but your lordships may keep. I
No, no,
will
no.
take photocopy, my lord. I have the copy, my lord.
Hey,
Let me have to read it.
Item number 7.
It's the same matter, my lord. When pension was claimed by the younger widow daughter,
what is the rule?
the rule is I printed out, my lord. 2021 rules. My lord, it is mentioned, it's page number 22. Page number 22.
No, where is 5483 of CCS pension rule?
Yes.
I want to consider this.
5483.
5483 of CCS pension rule.
But I have
Come to page 22 of the writ petition.
yes, 22, my lord. 22, my lord, it is stated in this connection, no objection certificate.
No, during course of audit, please read it.
Oh, during the course of audit of the claim, it is seen that that in supporting documents which is submitted with claim that Srimati Tanuja is the widow elder sister of the claimant, Srimati Tanuja Haldar, of the claimant, Srimati Tanuja Haldar. In this context, as per Rule 5483 of CCS Pension Rule of the Rule 59D and E of CCS Pension Rule 2021, family pension to the children shall be payable in the order of their birth, and the younger of them will not be eligible for family pension unless the elder next above him or her become ineligible for the grant of family pension.
So I want to consider 5483 of CCS pension vis-a-vis 59DE of CCS pensions 20.
But here 59D and E is there.
Where is 5483?
But in the said rule, my lord, I did not find it.
So bring that rule. Court has to consider this. Consider the validity of this order on the anvil of these rules. You bring that rule. You are representing the respondent. 5483 CCS pension.
Although
Not
the
today.
book, no, although I am equipped with the online.
Yes.
I have got it because the book does not contain.
The court wants to consider it.
Yes.
So you
I
have to
have
bring,
this in my online copy.
so bring the printout.
Milord.
Only the relevant portion.
Milord.
5483 CCS pension.
Milord. I
The
understand.
next day.
Eligibility.
Serial on Monday.
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 Milord.
Then, my lord, can you
Yes,
turn
take
back,
it.
my lord? I will.
Simply adjourn Monday.
Monday.
Because in reference to these rules, that is
Yes.
5483 CCS pension rules and
Yes.
Rule 59, which you have brought, this decision was taken.
54.
Now the validity or legality of this decision has to be considered
Yes.
in
That's right.
consideration of 5483 vis-a-vis 59DE CCS pension rules.
Yes.
So I want to consider both the rules. I remember the issue. Elder brother and elder sister and younger sister. Where elder sister is already getting pension due to death of her husband. Whether younger sister is entitled to get the benefit on.
Yes. That is the code issue, my. I love Leicester.
Well, Monday, Milord.
Monday.
Monday.
Not
this week.
Detained in the same position, my lord.
Yes.
Lovely.
Item number 8.
Sir, I'm appealing for the petition. Your
Lordship, I am for CSTC led by Mr. Biyani. Lordship, he is on legs.
I have
Kindly
submitted
keep
the
it short
deficit
Passover,
for fees.
Lordship. Kindly, Lordship, keep it short Passover. He is on legs. Mr. Biyani is appearing.
Not today.
Item number 9.
Yes.
It is that matter, my lord, 169.5 and above.
So far petitioner number 1 is concerned.
Mal.
Other, in respect of other petitioners, it was.
My lord, last occasion passed the order.
Yes.
It has still, it has
You
not
have
been.
preferred appeal against this order.
No. Why should I? My lord, the matter
Yes.
relates to, my lord, one.
Confine your case to petitioner number 1 only. Yes, place the facts.
My lord, this is the recruitment process of CAPF. My lord, initially petitioner participated in the PST and computer CBT and other formalities. After completion of other formalities, stopped in PST and PET level. In PST, initially
Standard test, where is the report?
that is, my lord, at page PST report.
Petitioner number 1.
My lord. Devashish Ghosh is the first petitioner.
24.
24. My lord. Initial rejection. 24, 26.
26.
26.
One 167.4.
My lord.
Height.
My lord.
Yes.
Before proceeding further, my lord, one thing I will show before your lordship, that is, your lordship kindly have a look. I mean,
And in the review, what was the measurement of height?
Before
review, where is the measurement of height?
Page 100. 100.
My lord, in
100.
One 169.6. So you are praying for exemption.
My lord.
A relaxation of height to the extent of 169.5. That is your case. Why you are taking so much time? Yes, he is entitled to get the benefit of 2D.
No.
Why not?
No.
Yes, why not?
But firstly, take the judgment of the coordinate bench, which is at page, my lord. Page, my lord, 108.
Yes.
He is asking benefit under the coordinate bench judgment. But kindly,
court is not saying this.
Right.
Court is saying that in terms of your revised guidelines dated 15th of May 2020, relaxation of height to the extent of 169.5 is permissible.
not permissible.
Let us come to this guideline. Show the guideline.
But guidelines is not been annexed.
You will show it.
Right. What my lord, first, my lord.
Let us come to the guideline.
No, but first let me come to the recruitment, my lord, the notice.
Where is the guideline?
My lord, I am sure.
Guideline is not applicable.
My lord, I beg pardon, it is my copy, marked copy.
May 2021. This guideline is dated
2015.
Yes, guidelines for review medical examination. Review medical examination, Army in Central Armed Police Forces and Assam Rifles. Yes.
But may I then first, my lord will not look into the guideline at first. But what is the stage of recruitment? Recruitment notice is issued. There's a guideline. Under the recruitment notice, the height is 170 centimeters. There is no relaxation in the recruitment notice. So at first, the candidates must pass the physical examination test. If the physical examination test they fail to achieve 170, that there ends the matter. They are not forwarded to detailed medical examination. Detailed medical examination only comes after the physical test. So once the candidate is declared to be unfit as per the recruitment rules in the physical examination test, there is no occasion to go
How
move it
this
forward.
relaxation is to be applied?
Relaxation is only to be applied in case of medical examination, that too in BMI.
That is not the.
Yes, that is the thing.
Please come to 2D.
Yes.
Please come to 2D.
Kindly place 2D. I'll place 2D.
Yes, read it.
Measurement of physical standards, that is height, weight and chest, is the responsibility of the physical test board for all categories of candidates. Well, I will not read. Medical officers will not be part of the PST board for both male and female candidates. Since presence of female is required during physical, not are not reading this. Now I will kindly takes after a few lines. In borderline cases of overweight, well, kindly mark overweight.
Yes, yes.
BMI should be considered at the time to arrive conclusion at the variation of 5 kgs plus and minus for the minimum maximum limit may be accepted. Similarly, while measuring
Yes,
height,
please accepted full stop.
Yes.
In BMI, height is one of the factors.
Height is one of the factors.
In borderline weight,
yes.
In case relating to weight of relating to weight, if it is a case of if it is borderline case, then height and weight is to be considered in order to arrive at a conclusion relating to BMI.
Yes.
That provision is there. You are absolutely correct. Then full stop.
Yes.
Similarly, separate provision. Similarly, while measuring height, fraction of centimeter less than 0.5 will be ignored.
Yes.
And 0.5 centimeter and more will be rounded up to the next highest centimeter.
But then
standard height and weight chart is attached.
Attached as an extra one. Kindly come to extra one.
Therefore, suppose a candidate in physical standard test is measured 165. Thereafter, in review, it is measured 169.7. If this benefit of relaxation is not applied at this stage, it will become your shoes.
No. No, my lord.
Similar argument was made before me. I have considered and I have passed on order. Therefore, I will consider this relaxation. I will pass an.
But may I place one more thing? May I place?
The identical argument which are advancing today, this was made by me on number of cases, but I have passed an order granting relaxation to the candidate.
Well, may I now place it in a different way? May I? But the whole argument of the union is that once a person knows very well what is his height in the recruitment notice. Recruitment notice is final and binding. Once he does not cross the threshold of 170 centimeters in the PST, he cannot have any further chance. And this chance only comes, my lord, at the time of medical examination, that too in case of BMI.
That is in case of BMI.
That only in case of BMI.
BMI, there is a separate provision similarly. In case similarly.
But kindly takes an extra one. Yes, kindly takes an extra one. That's why one extra one is relevant, my lord.
Yes. You go on arguing.
Kindly takes an extra one of that. An extra one says height in centimeter and the age in years with the weight. Age in centimeter with the weight, my lord. Height weight chart is given.
Annexure,
one to my lord, the
yes, page 21.
no, page 46 of that. But
Page 46
of that guideline.
মিলছে ম্যাচ করছে
46.
46 bottom portion, does it match, my lord? If it is not this copy, your lordship kindly have a look. Please.
Yes, page 46.
Yes, yes.
Male average body weight in kilograms,
Yes.
different age groups and heights.
My lord has found out.
Yes.
Now, this is the annexure 1 which is referred to in 2D. Now, if a person is of a more height and he has crossed, say, 172, he is 170. Let us take an example. He is 172.7. 172.7, my lord, kindly comes to 172, and his age is 18 to 22, and his weight is 67. So he will get that relaxation of 0.5 to get into 174, and his 67 kilo weight will be taken, and he will be selected to be medically fit.
It is in connection with BMI.
Yes, not in connection with weight in PST.
That is the purport of this.
No, my
Merely saying no will
well,
not.
kindly then I'll refer to. Well,
It has two parts. This relaxation clause under 2D has two parts.
Yeah, this is
borderline cases of overweight, comma. In borderline cases of overweight, comma, BMI should also be considered to arrive at conclusion, and variation of 15 kg plus minus from the minimum and maximum limit may be accepted.
Actually, similarly, this is BMI
while
calculation.
While measuring,
Yes, yes.
that is the height of
No, for BMI calculation.
measuring height, fraction of cm less than 0.5 will be ignored, and 0.5 centimeter and more will be rounded up to the next higher centimeter.
Yeah, and standard weight and height chart is attached.
And weight chart is attached.
So this is for BMI, not for PST. This is for calculation of BMI and not for PST.
Yes.
These two factors, because BMI is his height and weight.
I record your submission. Anything more?
My lord, one more thing.
Yes.
But while determining the other judgment by the coordinate bench, my lord, the coordinate bench heavily relied upon a judgment passed by the Madhya Pradesh High Court of my lord Arun Kalmodia.
No, no. Not heavily relied upon. Relied upon.
Relied upon. Now, my lord, Arun Kalmodia judgment has been set aside by the Honorable Division Bench of the Madhya Pradesh High Court. May I place that judgment? Though that is my lord. A similar issue. May I place from paragraph 11 onwards at page 6? May I place? In order to appreciate.
Just in.
আমার দেবো সিদ্ধার্থ Or 13 onwards are the, is the, my lord.
Yes, which paragraph you are relying?
But 13 onwards is the, my lord, 11 and 12 details the, my lord, the recruitment and the 2D. Now kindly comes to 13. 13 onwards is the ratio, my lord, of the judgment. 13 starts at page 16.
Come to paragraph, page 17, paragraph 14. Last 4 lines.
Yes.
The same can be read it.
171.
The
Yes.
same can be
Very well understood. Demo, if a person having 171.
that if a person is having 171 centimeter more than standard height,
Yes.
170
Qualifies for PST.
qualifies PST.
But at the
But
time of
at the time
BMI,
of BMI, there is variation
of weight or in height,
either there is variation of either in the weight plus minus 5 kg or in the height plus minus 0.5. If a candidate is measured 171, then what is the question of variation of plus minus 0.5 centimeter comes in?
no, 171 plus. It becomes 171.75, 171.
No, this example is given
Yes.
that the same can be very well understood by demonstration.
Yes.
If a person is having 171 centimeter more than standard height of
Yes, he is say 171.5.
qualifies PST, but at the time of BMI,
Yes.
there is variation of either in the weight plus minus 5 kg
Or a height.
if standard height, if a candidate weighs less than 5 kg of standard height, then to the extent of
while
0.5 centimeter,
calculating BMI, he will get this relaxation.
but at the time of BMI, there is variation of either there is variation of either in the weight plus minus 5 kg or in the height 0.5 centimeter plus minus.
Yes.
How does it make sense?
Well, may I explain?
Yes,
May I
explain
explain?
it.
But this this recruitment process is a one-way valve. This recruitment process is a one-way valve. Why one-way valve? You are less than 170, you are out of PST. Now, what, my lord, they want to do is they want to create a bypass out of this one-way valve to go into that detailed medical examination. They want to create a bypass by going in. I am 169.5 to 170. Since that relaxation is there in DME in calculation of BMI, give me a bypass. Now that bypass is not allowed under the recruitment rules. Recruitment rules doesn't say relaxation of 0.5 centimeter. Where it says relaxation is in calculation of BMI. So it is to be taken those people who has crossed that threshold of that one-way valve is more than 170.
I am on the methodology of
yes.
BMI.
Now methodology is annexure 1.
On the methodology of calculating BMI.
Yes. Now as later
now when the relaxation needs to be given in terms of BMI or
yes.
in the context of BMI, if a candidate weighs less than the requisite weight,
yes,
or
more or less, more or less.
What is the requisite weight?
Yes, given in annexure 1. Annexure 1 is that, my lord, page 46.
There is no such requisite weight.
Yes, average body weight.
Let us see. Page 43.
46.
Page 46.
Yes, a person who is between 18 to 22.
Page 46, yes.
46. A person who is between ages.
From your reading?
The first column, height in centimeter, age in years.
Page 46 of the writ petition.
Of the my lord.
Page 46,
46.
is a chart given.
Chart.
Age in years.
But a person.
Centimeter 156.
A person who is aged 18 to 22 years and he is 172.
Male average body weights in kilograms for different age groups and
yes.
heights.
Yes. So a person.
Height in centimeters 156.
No, don't take 156. 156 is involved for hilly candidates. Hilly candidates. Now, kindly
170
for normal candidates.
157 centimeter.
Kindly takes 18 to 22 years. A candidate is 18 to 22 years.
Average body.
No, kindly take a male at page 46.
Male average body weights in kilogram for different age groups and heights.
Yes. So, minor kind.
Now, heights, it is in case of male.
Male.
156, heights in centimeter 156.
And this is age 18 to 22.
44 is,
This is no, this is weight.
this is weight.
Weight.
156, 44, 54, then 46, 56.
This is age, according to age. My lord, kindly takes an example of
46, 56.
what is the age of 23 to 27?
Yes.
Age.
Age in years.
Age in years 18 to 22
56.
is the age
Then
of 20.
47, 58. Then 48, 59.
Yes, all are age, which ages?
But these are not the requisite age.
No, age is 18 to 22. First column.
I am considering the second line within the table.
Yes, first
against
consider the first line.
156, against height 156.
First consider the first column.
Yes.
Which is 18 to 22, which is the age of the person.
Requisite age.
Age, because age in years.
Nothing is stated age in years.
On
Nothing
top
is stated in this table.
On top, age in years.
For different age groups and heights. Not stated.
But height in centimeter and age in years.
No, it's not telling.
46, same thing is there. একই নিচের দিকে 46 দেখো, ওই তো ওইটাই তো।
Yes, height in centimeter, age in years.
There is no such heading.
First line, height in centimeters.
No, I want to know what is the requisite height and weight.
For a person who is 8.
Tell me under the advertisement and as well as in your guidelines, what is the requisite weight?
170 centimeters.
That is known to everybody.
Yes, and
Wait,
I will tell. Wait, I will tell. Wait time.
It's a formal chart.
Yes, formal chart.
18 to 22 age group.
No. Wait,
then
in
20 to 23 to 27.
recruitment.
156 height in centimeters.
And whether it is plus minus 5. If it is 170, in calculation of BMI 169.5 plus minus 5 as well. According to them.
According to them.
Plus minus 5. 170
5 kg plus minus 5 kg.
And
No,
we are
well,
saying
well,
in
let
case
me
of
tell
height
you.
also.
At the time of PST, weight is not taken.
Where is the requisite weight? Mr. Lyri, where is the requisite weight? Like 170 centimeter is the requisite height.
Yes.
What is the requisite weight?
But weight is not taken in PST.
I am not on this.
Yes.
Show me that where is the requisite weight.
Weight is taken.
Allow him to answer the query.
Or requisite weight is in the chart.
Nothing is there.
Yes.
18 years height in centimeters.
Yes, so 18 to 22 years, if he is 170, his weight should be 52 to 64. This is the chart, my lord.
If it is
if he is 18 to 22, the age, and his height is 170, his requisite weight should be 52 to 64.
Where 52 to 64 you are finding?
170, my lord, kindly drop down. And then 18 to 22, kindly drop down to the similar page.
Age group is 18 to 22, then it is 23 to 27.
Don't take the other part. Kindly take 18 to 22. Kindly drop down to 170.
Height in centimeters 170.
52 to 64, this is the weight.
But the heading is age in years.
But male average body weights in kilogram for different age group and height. This is the main heading. So age group is the first line, then the weights, and then the centimeters. Now person who is...
Therefore, your submission is, if height is 170 centimeter, that is
his weight should be between...
Then if the candidate is within the age group of 18 to 22, then his weight should be
52 to 64.
52 to 64.
Now, while calculating BMI,
if his age is 23 to 27, then his weight should be 54 to 66.
No. Yes, 54. Yes.
Then if his age is 28 to 32,
56 to
then
68.
56 to 68.
Yes.
Then 33 to 37, it should be 57.
Because these are relaxation because of SC, ST and everything.
57.5 to 70.5.
Yes, these relaxations are for, yes.
Wait.
Now say he is 170.6 and his weight is 69 kilos, 75 kilos.
Repeat it again. If a candidate is
170.6
and age,
say 174.5.
age is also relevant
Age is
factor.
22.
Within the group of 18, 22.
And his weight is 73 kilos.
Yes, there. If his age is if his weight is 70 kg.
70 kg. For plus 5. So he comes under plus 5. Plus 5.
So plus minus 5 kg.
5 plus 5
so
kg.
it can be brought down to 165. It can be brought down to 65.
64. Yes.
65.
And he will get the benefit.
Then how the height is a relevant factor?
Because if he's more than, say, if he's more than 170, say the next is 172. Kindly see, once the two jump is 2. The jump is 2 centimeters. So if he is more than 170, he goes more than 171.6. Then he gets the benefit of the height of the weight of 172.
If it is 171.2.
If it is 172, then weight should be 54 to 66 in the age group of 18 to 22.
He gets that benefit.
To the extent of 5 kg.
5 kilos.
It will be. It is required to be lowered if the weight is 67.
67.
Weight is say 70.
But if he is 70,
even weight is 70,
then he goes out.
Age group of 170 and height is 174. Then it
no, don't consider 174. Finally consider 170 and 172.
172. If it is 172, then
he gets the benefit of that 5 kilos.
If height is 172 and weight is 54, not in between 54 and 66.
Yes.
Suppose weight is 66.5.
Yes. He doesn't
then
get
it can be brought to 66.
Yes.
In terms of height.
Yes.
And get the benefit of
get the benefit. Yes.
So how the height comes into place?
No, if he is 171.6, because if he is 170 to 172, he doesn't get the benefit of 172. If he is say 171.6, 171.7, we give them relaxation of 172, increase it by 5 years, 5 kilos and give them the benefit. But if he is 80 kilos, how can we give the benefit? So it is a one-way valve. The first valve ends at PST, the second valve ends at BMI.
So therefore, against 172, you are saying that if it is 172, then weight is 54 in between. Weight should be in between 54 to 66.
And he gets
now,
the benefit.
If it is found that if the candidate is overweight.
Say candidate is 171.6. 171.6. So I give him the benefit of 1672 and give him till 66 kilos.
Yes.
Here it is 64, ending at 64, I give him benefit till 66. He will be upgraded in the chart. But if he is more than 66, he is say 70 kilos, I cannot give him. His valve is closed there. He doesn't go beyond the DME. So once the one-way valve at PST closes, the candidate who has crossed through that valve gets this additional benefit in considering of BMI. He gets the relaxation of weight and height following this chart. Now, if he is more than overweight, he doesn't get the benefit, he is out of DME. We are sorry. This is a, my lord, recruitment process, my lord. Recruitment notices cannot be, my lord, tweaked.
Now, once if anybody's height is 172.6,
yes.
172.4, it is less than 0.5.
Then he comes under 172. then he only gets the benefit
In
of
order
this.
to match the height.
Yes.
Weight.
Yeah, wait.
Now, suppose if a candidate's height is 172.4, say,
4, and his weight.
And his weight is in between 54 and 66.
Sigma, he gets 5 kilos plus. He gets 5 kilos plus. So 66 plus 5.
Then he is coming within the parameters of 174.
No, he doesn't come. He gets that benefit of 5 kilos here.
So this adjustment is at a time of medical.
Medical.
Chup, chup. File your affidavit.
I will file.
There's a logic in it.
My lord,
Though I have passed several orders.
my lord has
This
passed
has
the
to be addressed.
my lord has passed the several orders that has been tested before the honorable division bench, allowed, that has been tested before the Bolch. That has been tested before the honorable apex court, SLP dismissed.
Is it so?
Tushar Singh, my lord has passed the interim order.
Why you are not saying this?
Yes, this is the.
My lord,
Your
that
lordship's order, interim order, affirmed by the coordinate bench, appeal preferred, appeal dismissed, up to Supreme Court.
that is Tushar Singh.
I have annexed.
That is one way.
This is the interim order passed by your lordship.
Last year's.
But we have 3-4 submissions. And various cycles Tushar Singh was referred in our country.
Which order did you show?
হ্যাঁ এটা বলুন হ্যাঁ ওইটাই হ্যাঁ
So I permitted them to participate. Now, where is the order of the
Division first bench, my lord, that one first bench. And subsequently thereafter the back. Yes. In that day.
Another.
In which order was affirmed and the person
Not affirmed.
got the benefit.
Yes.
Appointed.
Appointed.
Joint-
Now, kindly see the Supreme Court. Kindly see Supreme Court.
Yes. Facts.
My lord, that's the Supreme Court.
Yes.
Kindly read the.
15th April 2024.
Yes, kindly, my lord. No. Yes. I'll read the last paragraph. In the facts and circumstances, we are not inclined to interfere the judgment and order passed by the High Court.
What about the division bench, Mr. Lahiri?
Kindly read the paragraph 4. Kindly takes paragraph 4. However, the question of law is kept open to be considered in appropriate case and order passed by the High Court shall not be treated as precedent.
What about the division bench order?
Division bench didn't upheld, didn't do anything. They said that they are giving the jobs, let them get the jobs. So point of this is
Identical point was taken. It is contended on behalf of the petitioners.
My lord, Supreme
Petitioner,
Court.
since the petitioner's height was found to be 169.5 centimeter, on measurement he is entitled to receive the benefit of clause 2D of the aforesaid guidelines, and upon giving relaxation, petitioner ought to have been.
But kindly takes internal page 2.
It is submitted that since the height of the petitioner was found to be less than 170 centimeter, he has not been permitted to participate in the physical efficiency test.
My lord is reading the order of the division bench.
My order.
Kindly then takes division bench.
Yes.
Kindly
Then
takes
this was
division bench.
tested before the division bench.
Yes.
You have complied with this order.
No, division bench is say what the division bench has said. Division bench has not gone into the merit.
Since they have complied.
Answering our query,
yes,
learned ASG submits upon instruction that in the event the writ petitioner emerges to be successful in the PT, RME and DME,
yes,
his name shall be included in the final
yes.
select list.
Now I challenge this before the Supreme Court. Union goes where Supreme Court says this is not to be taken as a precedent. It is open.
Yes.
Height question remains open. The law question is open. This only belongs to those petitioners and not to any other else.
My lord, another thing.
No.
Another
Yes,
thing.
yes.
My lord, kindly see, this was 2D has been applied in a one candidate and given 170. They themselves applied the 2D, clause 2D, and now they are opposing.
Measurements 168. How you are saying female candidates 157?
My lord, height remeasured next page, very next page.
Yes.
Initial measurement was 168.6 and remeasured 169.5 plus 5 error 170
Where
centimeter.
from you are reading?
Well, second page, last portion, bottom portion.
Final result. Under
Final
the heading,
result.
final result.
Height,
Under the heading final result. 6.
Six. Yes, final result. Under the heading final, right. Qualified.
Where is the measurement of height?
Melody. In handwritten. Next page.
First page. 168.6. It is struck off.
It is struck off.
Yes.
And thereafter, Melody remeasured. Next page.
Where is the measurement of height?
169. 169.5.
169.5.
Bottom portion.
Yes.
DIG made it. Plus 5 error 170 centimeter. Finding qualified.
Qualified.
Applied to
instruction. This is a paper
Yes,
coming
file a
now.
supplementary affidavit.
Why has to file by supplementary affidavit?
Yes. You
No,
take
no,
instruction.
another thing. Recent year. This year. On the
Which year
basis
is
of
this?
25 recruitment process. My dear Lord, এটা just একবার দিন।
Which year? 24. This is 24.
On the ওটা 24.
So what?
Rule was applied. ওটা 24. এইটা
Let's file a supplementary affidavit. I will take instruction.
24.
No,
It is
24
applicable
doesn't
in
matter.
the
No, 24 doesn't matter.
situation.
Let them file a supplementary affidavit. We'll take instructions.
Yes.
দাঁড়াও না, আমি বলি না, তুমি তো 1 ঘন্টা ধরে বললে। মানে
Yes.
on the basis of the Patna High Court, relying upon this, they have allowed to sit in the participate in the DME.
Provisionally.
Patna High Court judgment case pending আছে যদিও।
Provisionally.
It's required to mention the case is pending.
Order है provisionally apply किया है.
Provisional.
Please sir, do not go back. What is he saying? Subject to writ petition.
When the a medical examination is scheduled.
Going
Medical-
on.
Completed till 9th.
It will complete on 9th.
9th.
Allow him to participate, subject to final result. As
Grateful.
Patna High Court has opined, said. Because ultimately writ petition is allowed, then there will be no medical
My lord.
scope of medical.
Grateful to your lordship.
And
That can be done. That can be done.
And my lord, that interpretation clause 2D, my lord, while measuring height, measurement part is to the PST level. They themselves, they are saying that the DME cannot measure. My lord, last line, similarly, while measuring the height. Very important.
Will come when.
Clause 2D. My lord, it is
But
Conjoint-
why not?
conjoint, my lord, it is conjointly read. I am reading measurement of physical standard of his height, weight, and chest is the responsibility of the physical standard test board for all categories of candidates, that is GOs, SOs, and others. Stop. Medical officers will not be part of PST board both for male and female candidates. Stop. My lord, I am pausing here. Now, similarly, while measuring height fraction, but while measuring height, measurement at the stage of DME, no measurement. If it is not measured, if it is not benefit is given, 169.5, 17, he cannot go into the melody.
in case of overweight, BMI should also be considered to arrive at a conclusion in variation of. Similarly, while measuring height fraction of centimeter, will be ignored at 0.5 centimeter. Mr. Lahiri.
What is he
Mr.
saying?
Lahiri,
Yes.
please come to.
I'll explain.
No, please come to 2D.
Yes,
Please
I will explain.
Please come.
Well,
There is an indication. Please come.
Grateful to your lordship.
You have said that to the extent of 0.5 in terms of height is to be applied while arriving at a conclusion relating to BMI, which relates to overweight.
Yes.
Or weight of the candidate.
Now
they are plus minus 0.5 is necessity. Suppose you have given an example that 171.5 or 172.4. 172.4 if is the height, it will be brought down to 172.
No.
In order to, please wait. In order to consider the eligibility of the candidate in terms of the weight.
Yes.
Please come to the relevant part, that chart. Please come to relevant part.
Yes, I'm here.
172, if height is 172, then 54 to 66 is the should be the height. Now, if anybody's height 54 to 66 kg should be the weight. Now, if anybody's height is 172.4.
No. Take an example of the extreme case.
Say 4. Now you are saying suppose the weight is more than 66, or if the weight is
he gets plus 5 in weight.
50.
So he gets 66, 67, 68, 69, 70, 71.
So in order to know, you are saying that suppose height is 172.4.
No, don't take it that way. Well,
please.
Yes.
Height is 172.4. And his weight is 54 to 66.
No, say his weight
54 to 66. To get the benefit of 54 and 66, his height can be brought down to 172.
No.
Yes,
Let me
yes, that you have said.
Yes, let me explain.
Let us come to 2D.
Yes.
Please come to 2D.
Yes.
Similarly, while measuring height fraction of centimeter less than 0.5 will be ignored. And similarly, while measuring height fraction of less than 0.5, not more than, less than 0.5 centimeter will be ignored. And 0.5 centimeter and more will be rounded up to the next higher centimeter.
Yes.
So therefore, there is no question of bringing down the height of the candidate from 172.4 to 172.
No, man, let me explain now.
Sorry.
Let me explain once again.
No,
Let me explain once again.
no, your understanding is
No.
is wrong.
Let me explain.
Because
No,
please,
let me explain.
you have given the example,
Let
very
me explain.
specific example, and your officer is nodding his head correctly.
Let
That
me-
yes, in height 172.4,
No,
you have said in 172.4 if height is 172.4, but weight is
No.
54 to 66.
Kindly.
In the age group of 88 to 22, in that event, his height can be adjusted to the extent of 0.5 centimeter less in order to bring the candidate within the weight of 54 to 66. But that is not the purpose of 2D. Come again, 2D, it says it does not contemplate lowering of height. It contemplates hiring of
Yes,
height.
well, I'm
So
example.
it says that it says similarly while measuring height fraction of less than 0.5 will be ignored and 0.5 will be rounded up to the next higher centimeter.
My kindly takes this chart. This is 172 to 174.
There is no scope
No.
for lowering the height
What I have
in order to bring a candidate within a parameter of height. Considering the height
let
of
me
the candidate.
re-explain. Let me re-explain. A candidate is 172, 173.6.
Mr. Mondol, come back on next Tuesday. In the meantime, I'll permit you to participate in the game.
Grateful to your lordship, my lord. We are grateful.
Yes.
But within a week, I cannot file my opposition. Within a week.
And you file a supplementary affidavit.
Yes. Shall.
Matter is heard at length in presence of the learned advocates representing the petitioner and Union of India. Question arises for consideration whether petitioner is entitled to get the benefit of relaxation as contemplated, benefit of relaxation of height as contemplated under clause 2D of revised guidelines dated
15th of May 2015.
As the petitioner in physical standard test was measured as the petitioner in review was measured 169 as the height of the petitioner in review was measured 169.6, which is less than 0.4 centimeter. Next paragraph, Mr. Siddhartha Lahiri, learned counsel representing Union of India has strenuously argued based on clause 2D of the revised guidelines dated 15th May 2015 that contemplation of extending benefit of that provision of extending benefit of that contemplation provision code, that provision of extending benefit of relaxation of height to the extent of 0.5 centimeter is a relevant factor at the time of measuring BMI of a candidate if weight of the candidate does not come within the requisite parameter. Stop. Next paragraph. However, during course of hearing, parties have relied upon judgments of different courts in order to substantiate their respective cases. Stop. In one of the orders passed by Patna High Court dated 23rd September 2025 in Krishno Nandan Mahato, MAHTO, Mahato, and another versus the Union of India. In similar situation, court permitted the in medical examination. Stop. It is submitted on behalf of the petitioner that medical examination is going on and it will continue till 9th December 2025. Stop. Next part. Considering the rival submissions made on behalf of the parties, court finds the issue needs to be considered further, thereby granting opportunity to the learned advocates representing the parties to make further to make submissions. To make submissions. Stop. Hence, concerned respondent authorities are directed to permit the petitioner to participate in medical test, which is continuing at present, subject to final result of the writ petition. So, leave is granted to the learned advocate representing leave is granted to the petitioner to file a supplementary affidavit to bring on record other relevant documents by 7 days from date and file by 7 days from date, and a copy is to be stopped. A copy of the supplementary affidavit is to be served upon the learned advocate representing the respondent. List the matter for further consideration under the same heading on 18 December 2020.
Grateful to you. Deeply obliged.
Mr. Lahiri, please apply your mind. There is no provision for lowering down.
Hiring, yes, hiring, yes.
Very attractive submission has been made, but it appears
I'll try to convince.
It appears prima facie contrary to the issue involved.
No,
hearing
yes,
hearing you more.
Or may I get it back, or it will be kept in?
Yes, you can take it. Okay, ওইটা দিয়ে দাও তো দেখি।
Mano retains the judgments and returns back the
Yes, do you want to get it?
No, retains the judgments but return the
right.
guidelines.
এইটা দাও, ওই সাপ্লিমেন্টারি এফিডেভিট করবে। It is dated 15th May 2015.
Yes.
Revised guideline.
Yes. Or need not be searched out. Copies are with us. Great.
In case of weight, plus minus 5 kg. But in case of height, only hiring.
Yes, higher, not lower, higher.
But he said
My lords, kindly to mention matter ready for hearing. Only the point of challenge is the issuance of the charge.
Hearings are not including now. When I will include, then mention.
For hearing, my lord. This is also a matter for hearing.
Wait for something. I'm not
Last
including.
week I had come, my
No,
lord.
I'm not including
December.
any hearing
But
matter.
this person is without his salary. for
Sorry,
12
sorry.
Last 1 year.
Please call the list. মান্থলি লিস্ট পরে হবে, আগে তো সাপ্লিমেন্টারি লিস্ট হবে। হ্যাঁ, ওটা আপনার কাছে রাখুন, পরে দেবেন।
Your side item number 1.
This list বলো।
My lord, kindly see the last order of your lordship on 26th November.
For the respondent, Transport Corporation, my senior Devlina Chattoraji is online, virtually.
Nobody is on virtual mode.
My lord, I am appearing online.
Yes.
May I kindly see the last order, 26th November. My lord was pleased to direct the respondent authority to take instruction about the
Oh, I see.
payment.
Just a minute.
Yes, my lord.
Yes, what is your instruction?
My lord, the petitioner, my lord, his disciplinary proceeding has been, my lord, dropped because of the reason of superannuation. And my lord, so far I have received the instruction that some of the amount has been paid to the petitioner, and the remaining amount that is already under process. The petitioner will be paid, my lord.
Adjusting the subsistence allowance, the area salary petitioner is entitled to get.
Yes.
During the
My lord,
period when petitioner was placed under suspension.
Yes, my lord. My lord, the copy of the instruction is there with my junior, my lord. I request her to provide it.
May I have a copy of the same, my lord, if your lordship so desires?
So after payment on 1st December 2025, 7,24,000, that means day before yesterday it was paid.
Yes. Yesterday only we have received.
It has been paid already.
But I will have to take instruction. I am not aware of, because I didn't receive the instruction.
Your client has been paid. That's why you are not aware of. He would not, if he would not have been paid, he got instruction.
That may be, my lord.
Yes.
That may be, my lord. May I just, my lord, have a copy of the same, my lord?
No, I'll dispose it of today.
My lord, so far as the payment is concerned, my lord, may I come back with the instruction, my lord? I do not know. They are saying that
the client is not interested to meet you now.
No. The second matter is also
Why? Because it has been paid.
Second matter is also of the same petitioner before your lordship.
If there was no payment, yesterday night you would have received phone call. Nothing has been paid.
my lord, may kindly permit me to take instruction.
Yes, anything is left after payment on 1st of December.
My lord, I believe so. Something is left because I have been over the telephone call, my lord. I have been informed that some payment has been made and the other payments are being processed.
So the rest of the payments which are required to be made to the petitioner, you make it by fortnight.
Yes, yes, my lord. My lord, the next matter is also with regard to payment of PF due interest on PF, my lord, of the
No,
petitioner.
PF as well as interest. Next matter.
Yes,
I will
yes,
consider the next matter when the next matter will be called on.
yes.
My lord, may I have a copy of the same?
Matter is yes, give a copy to.
Okay.
Matter is heard in in terms of the order dated 26th, matter is heard in terms of the order dated 26 November 2025, learned advocate representing West Bengal Transport Corporation Limited, herein after within bracket herein after referred to as corporation, close bracket, has submitted a copy of the letter dated 2nd December 2025 issued by the Chief Accounts Officer in charge, issued by Chief Accounts Officer in charge, and same is taken on record. Same is taken on record. Next paragraph. On perusal of the said letter dated 2nd December 2025, it appears that after superannuation of the petitioner on 30th June 2025, leave encashment, gratuity, leave encashment and area salary to the tune of rupees 548,790 was paid to the petitioner on 22nd August 2025. Stop. In addition thereto, adjusting subsistence allowance, petitioner was paid area salary to the tune of rupees 724,248 on 1st December 2025. Stop. However, it is submitted on behalf of the said corporation as disciplinary proceeding initiated against the petitioner was abandoned due to his superannuation on 30th June 2025. He is entitled to get some more payments towards area salary, adjusting subsistence allowance. It is also contended that steps are being taken to settle the claim of the petitioner and it is to be paid soon. Next paragraph. Petitioner is represented by learned advocate. Next paragraph. Concerned authority of said corporation is directed to release the rest of the amount payable to the petitioners towards arrear salary during the period when petitioner was placed under suspension, adjusting subsistence allowance by fortnight from date. Stop. At the time of making such payment, final statement of calculation shall be handed over to the petitioner.
Grateful to your worship.
Stop. With the aforesaid directions, writ petition stands disposed of urgently.
Grateful, my lord.
Next. My lord, concerning the same petitioner, my lord, the provident fund has not been released because of the pendency of the disciplinary proceedings, and part of the leave salary has been paid. Full leave salary has not been paid. I have taken a specific.
You are sure that it has
Yes,
not
my
been paid?
Yes, my lord.
Till date?
Till date. Kindly see the paragraph 5 last.
Or in the midst it has been paid?
No. Calculation sheet.
You have no instruction.
No, calculation sheet I have not seen. So far as it had been handed over.
Petitioner retired on 30th June 2025.
That is.
Thereafter, leave encashment benefits and gratuity was paid, but provident fund was not paid.
Provident fund was not paid, and the leave encashment during the period of suspension, that was also not been paid.
So that's why they are saying that some more benefits are to be required to be paid. It is confined to provident fund only.
Only provident fund and part of the leave salary.
Where you have paid that the leave salary is required to be paid, or there is a prayer to that extent for payment of leave salary.
Well, that prayer has not been taken. I have.
So why you are expanding the scope?
And other dues, if any. I have mentioned and other dues, if any. And in my averment in paragraph 5, I have specifically
yes,
said,
why provident fund has not been paid?
My lord, generally these payments are released by the state, my lord. Requisitions are sent and the payments are being released by the state. So, my lord, we are at the hands of.
When the requisition was sent?
My lord, since the disciplinary proceeding of the petitioner has been recently dropped, so my lord, the requisition has been sent after the dropping of the.
Tell me the date of sending requisition.
My lord, I do not have the document with me.
What is your instruction so far state is concerned? So you both of you take instruction and on the next date apprise this court when the requisition was sent to the concerned state authority for remitting provident fund amount to the account of the petitioner.
My lord.
Issue. Matter relates to release of provident fund dues to the petitioner due to his superannuation on 30th June. On 30 June 2025. Stop. Petitioner was an employee of
Calcutta Tramways Company, renamed as West Bengal Transport Corporation.
West Bengal Transport Corporation. West Bengal Transport Corporation Limited. Within bracket, hereinafter referred to as said corporation, close bracket. Next paragraph, it is submitted on behalf of said corporation that due to superannuation of the petitioner on 30 June 2025, disciplinary proceeding which was initiated against him was abandoned. As a result whereof, petitioner is entitled to get retirement dues, including provident fund. Stop. It is also submitted that provident fund is paid by the state authority based on requisition sent by the state corporation. Stop. Next paragraph. On query being posed to the learned advocate representing the state corporation, accommodation is prayed for to apprise this court that when requisition was forwarded to the state respondents for releasing provident fund dues to the petitioner. Stop. State respondents are represented by learned advocate who has also prayed for accommodation to obtain instruction. Stop. Hearing of this matter stands urgent. List the matter under the same heading for further consideration on 16 December 2020. Wednesday. On 17 December 2025. Stop.
Grateful, my lord.
Part number 3.
For the petition, this matter, my lord. This matter, my lord,
whether this matter is maintainable on the original side. In a similar matter, my lord, your lordship was pleased to pass an order, my lord.
That part has already been settled, my lord. I will then, my lord, show to your lordship the judgment of this coordinated bench, and they went up to Supreme Court, and Supreme Court dismissed the SLP, my lord.
That's on a separate point, not on this point.
At this point, my lord, I will show to your lordships against the Eastern Coalfield.
Does not create as president.
So without knowing that what is being shown, you are saying that Supreme Court judgment is there on.
No, I don't know, my lord, whether what my learned friend is showing, but I don't know, my lord, whether my lord,
learned friend is submitting that since all the respondents are offices of all the respondents situate outside the jurisdiction of outside the original side jurisdiction of this court, writ petition in the original side is not maintained.
I understand, but my lord, if you lord,
so convert the writ petition into a writ petition in the appellate side and mention the matter. I pass similar order. I do not entertain the writ petition in the original side if any of the respondents or at least one of the respondents office is not within the jurisdiction or within the original side jurisdiction.
My lord, against the Eastern Coalfield, my lord.
Yes, show me that which Eastern Coalfields it is at.
My lord, if you lord kindly see, my lord, then this kind of matter, my lord, they have severally raised the issue. I don't know whether that was, my lord, cited or placed before your lordships or not. My lord, if you lord kindly see the division.
You are the officer of Eastern Coalfield. You are an employee of Eastern Coalfield.
Yes.
So this chairman come managing director, bad one.
my lord.
Director ECL Bardwan, Deputy General Manager Poschim
But
Bardwan.
a similar matter, my lord, if your lordship kindly allow me to place.
I know similar matters are, but I do not entertain this.
My lord, they have.
In order to get the matter heard early, I do not entertain this unless until it comes within the jurisdiction, original side jurisdiction of this court.
My lord, there are, my lord.
I am not dismissing your writ petition,
that I know.
but it will be converted into the writ petition on the appellate side.
In a similar matter, my lord, it has been, my lord, decided. If your lordship kindly allow, possibly, my lord, this order will not place before your lordships, my lord. I don't.
All were placed in other jurisdiction determination also.
This judgment.
Yes.
This matter, my lord, may I then, my lord, come back, my lord? Let me, my lord, check this order, my lord, and come back.
What about respondent number 1?
1, my lord, I say, my lord, ECL's, my lord, all functionaries are in Bardhaman, my lord. Here, my lord, he has shown an address, 13 Naren Mukherjee Road. It was previously an office. Now it's not
But
an
till
office.
date,
It's a guest.
till date, it has a office. My lord, kindly allow me, my lord, place the judgment, my lord. My learned friend has argued.
I am not dismissing your matter.
A similar matter, my lord.
No.
Similar issue, my lord, my learned friend has argued, my lord.
During course of hearing,
One thing, this order. Expert number 10 and 11, I see. They are good functioning.
No.
that will be considered later on. During course of hearing, it is pointed out that all the respondents, offices of all the respondents situate outside the jurisdiction, outside the original side jurisdiction of this court. Stop. Therefore, it is found that writ petition on the original side is not maintainable. Stop. Next paragraph. Leave is granted. Now, next paragraph. Department is directed to convert this writ petition on the original side into a writ petition on the appellate side by completing necessary formalities and allot appropriate number to this writ petition.
My lord, direction may be given to place the matter in the, my lord, list, my lord.
And next paragraph, learned advocate representing the petitioner is directed to cooperate with the department in completing aforesaid exercise. Stop. Next paragraph. After the writ petition is converted into, after this writ petition is converted into a writ petition on the appellate side, leave is granted to the learned advocate representing the petitioner to mention this matter. Stop. One notice to the others.
Item number 4.
I'm out of time filing my reply. They have served me with their opposition. Lordship may extend the time for 2 weeks.
Previously, I have extended time
for them to file opposition.
Show me the order.
Oh. Action.
Lordship's last order.
দেখি এক মিনিট একটা লাইন অ্যাড করে দেবে তো মাঝখানে একটা অ্যাপ্রোপ্রিয়েট
সেদিনই পেয়েছিলাম অপোজিশন
that it is also submitted by the learned advocate representing the respondents that address of the respondent number 1 has already been changed. ওই হেন্স এর আগে সেকেন্ড প্যারাগ্রাফের আগে এটা কি ঢুকিয়ে
But I stand
Yes,
corrected.
where is the just a minute.
Yes, I stand corrected when on the last day.
Affidavit in opposition is filed today and the same is taken on record. Right, you are representing the petitioner.
Yes.
Right, advocate representing the petitioner has prayed for extension of time to file affidavit. Reply. Time to file affidavit extension fortnight. Yes.
Because on that day,
29th October, it is extended.
Yes. Because I stand corrected because on that day in court they filed the affidavit in opposition. That is why the time to file reply was already over. That is why Lordship extended the time. But I am out of time even today. The first line Lordship has recorded that we have filed the opposition today.
It is 29th of October 2025 order.
Yes.
Subsequently, another order was passed.
That was the last order. That's the last order.
But it was extended for a period of fortnight.
Because the time was granted from that day because opposition was filed on.
Why you have not filed? Already
I-
fortnight
I-
period is over.
There is no excuse, my lord. It's being prepared. If it will be filed if your lordship grants me 2 weeks time, or
You are the petitioner and you are not filing the affidavit in reply. It's an assigned matter.
I don't have any excuse, my lord.
The pay cost for 7 days, 70,000 rupees. Well, I am bringing it down to 50,000.
Lordship, can we condone the cost for it? He is situated outside.
29th October, 15 days.
I do.
Today we are on 2nd December, 3rd December.
But I have nothing to say, my lord. I can't argue with this. Facts are there. Your lordship.
30 days time is over.
That's over. That's over. If lordship grants me 7 or 10 days time, my lord, he is situated outside.
Learned advocate representing the petitioner has prayed for further extension of time to file affidavit in reply. Respondent, you are representing bridge and roof.
Yes, Your
Respondents
Lordship,
are
all the
represented by all the respondents.
Yes.
Respondents are represented by learned advocate. Time to file affidavit in reply stands extended for a period of stand extended by 7 days. Stop. Such extension of time to file affidavit in reply. Such extension of time for filing affidavit in reply is peremptory. Stop. List the matter under the same heading for further consideration on 17 December 2025.
Yes.
Lordship, last occasion, your lordship has directed us to make the necessary work before the BLR or London BLR authority, your lordship. We have made an application and the hearing has been concluded, your lordship.
Yes.
On the last occasion, your
There
lordship.
is conversion of the land.
Yes, your lordship.
In the name of small
tools. Yes, your lordship.
Matter is taken up.
And the hearing has been concluded, your lordship.
এখন অর্ডার দেবে কনভার্সন তারপরে মিউটেশন হবে একটু ফ্রি ফ্রম অল এনকাম্ব্রেন্স অ্যাকশন করে দেবে তো না কোর্টের মানে থাকলে সঙ্গে ঝাম করে দেয় কি তোমার ক্লায়েন্ট রেডি আছে রেডি আছে
Now, you made an application on 17th October 2025 for mutation.
Yes, your lordship.
When it was heard?
On 20th November, your lordship.
20 November or 28 November?
20th, 20.
20 November, 20 November.
20 November.
No order has been passed till date.
Yet I'm waiting for the order, your lordship. This is a
The
notice.
warehousing corporation has come forward. West Bengal
West Bengal State Transport
State
Corporation.
State
Transport Corporation.
State Transport Corporation.
Whereas in corporation. West Bengal whereas.
Warehousing corporation has come forward to purchase the land.
Yes, Your
Along with this, Mongolam Construction is there. They have made an application.
Yes.
The Mongolam Construction has made an application.
Yes, Your Lordship.
Now the bid which is to be made by the respective parties is to be considered, and the highest bidder is to be considered for purchase
Purchasing the
of the
property.
land in
Yes.
question. But prior to that, this mutation is
It has
necessary.
to be done.
You have filed an application.
Yes, my lord.
Additional party
Interview.
intervene.
For warehousing corporation, nobody has come forward.
Come through a letter, my lord, but subject to the
What is
mutation
applicable?
has been done.
Yes,
They-
yes.
They have approached before us through letter, but not through any affidavit or application, my lord, not yet.
Then suppose tomorrow an order is passed allowing mutation.
I will.
Then how you will negotiate with warehousing corporation?
I will.
What I understand, Your Lordship, they want to be mutated, this land to be mutated in the actual owner's name, so that they can now come forward. After that, I think, I mean, as per my understanding, that after doing this, they will definitely come and quote the price, as per my understanding. They are waiting for this mutation to be done, conversion and mutation.
And you are waiting for the deal so that payment can
Yes,
be
Lord,
made.
yes.
How long this will continue?
Long time elapsed, my lord.
Well, may we assist my land?
At least I have passed 40 orders.
Yes.
Your Lordship kindly direct, may we assist my land?
And this is continuing from 1998.
Sorry.
This is continuing from 1998 writ petition, when I joined the bar.
My lord, if your lordship kindly direct, then we may assist my learned friend to get the matter converted and mutated within a very short period of time. So for my instructions concerned,
That is not the scope of this writ petition. If petitioner is not otherwise eligible to get the order of mutation, well, the court in this writ petition cannot direct. As is where is basis, court has to consider this issue, whether the land can be sold out or not.
Yes, Your Lord, as is where
It's a different issue. So far mutation is concerned.
Yes, Your Lordship.
It will be in accordance with law. If there is any infraction of law, then authority will not mutate. Now in this writ petition, and I cannot direct the authority to mutate the land. That will be a wrong order. So this court has certain predicaments. Since I am sitting in this chair, I cannot pass any order which I want.
Hands are tied, Your Lordship, because this property should be sold as is where is basis.
my client is ready to purchase the land.
How long time is required to get the order of mutation? It was hard on when? 20th November 2025.
I have heard that due to SIR, the BLRO is not available.
No, my lord,
Due
I
to
submit.
SIR.
Due to SIR, no BLRO is required at present condition, my lord. So for my instruction concerned,
After 14th February,
maximum
they
it
will
take 15
Issue.
pass an order by the BLRO, concerned BLRO.
Land advocate representing the petitioner submits that an online application was made on the portal in terms of memo number 1375 dated 12th August 2025, issued by the Assistant Director within bracket WBLRS close bracket and Block Land and Land Reforms Officer, Krishnanagar 1, Nodia. Seeking mutation of the land in question. Such application was made on 17th October 2025. and it is submitted today on behalf of the petitioner that hearing was concluded on 20 November 2025, but order is yet to be received. Stop. In view of the aforesaid situation, hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 4th February 2026.
14th. Till 14th, SIR will continue.
Let me see. Always I find that you pay for more time. Why? This does not instill confidence in the mind of this court.
No, my lord, I have heard that till 14th February, the SIR will go.
Come back on 4th. Always you try to buy time in this matter, I find. The reason is not deciphered so far this court is concerned, but court will try to decipher it. Yes. Huh? Court applications gulo take now. Try to get the order of mutation as early as possible. Yes, next matter.
December, item number 1.
Apply for the petition in this matter, my lord. Here, my lord.
Who is the other side?
I have served everyone, my lord, and
First time.
first time.
Service is completed at time of filing.
Yes, my lord.
Are you aware of who is appearing for the respondents?
No, my lord.
Who are the answering respondents?
Whole India, my lord.
Serve another notice upon, if possible, upon the learned advocate.
My lord.
Issue. In spite of service of notice, respondents are not represented. Stop. Learned advocate representing the petitioner is directed to serve notice upon the respondents or the learned advocate representing the respondents, enclosing copy of this order by December 9th, 2025. List the matter under the same heading for further consideration on 17 December 2025. If it is possible, try to serve upon the learned advocate.
My lord.
Court finds that it is effective.
My lord. My lord.
Item number 2.
Apply for the petition in this matter, my lord. This matter, my lord, relates to, my lord, the compassionate employment. Here, my lord, no, CMP only. Here, my lord, what happened? The father has died, and my lord, under the national coal wage agreement, up to 35 years, the
Who
petitioner.
is happening for the other side?
My lord. First time, my lord.
First time.
First time.
This is old service of 27th October 2025.
My lord.
That matter is to be moved before a different court.
My lord.
To serve another notice and
Very well, very well.
issue. In spite of service of notice, respondents are not represented. Next paragraph. Learned advocate representing the petitioner is directed to serve notice, enclosing copy of this order upon the respondents or the learned advocates representing the respondents by 7 days from date and file affidavit of service on the next date. List the matter under the same heading for further consideration on 17th December 2025.
Item number 3.
Yeah, I am for the petitioner, my lord, led by Mr. Supusai Chatterjee. He is again in another court of my lord.
I am for the.
Who is, you are led by whom?
Mr. Supusai Chatterjee, learned advocate.
You are representing all the respondents. देखिए फाइल का दाव तो.
I am for the state answering respondent of the CSTC. My lord, kindly see the page 46.
Second round of litigation, my lord.
West Bengal Transport Corporation, who is representing?
Sir.
Yes.
My lord, this is
She is appearing for the Transport Corporation. She is appearing for with Transport Corporation and the state. All respondents are represented.
yes, ma'am. I am seeking short Passover, ma'am.
Not today.
Not today.
Record an order. At the time of call, accommodation is paid for on behalf of the petitioner. Stop. However, respondents are represented by learned advocates. As a last chance, hearing of this matter stands adjourned. Stop. List the matter under the same heading for further consideration on 10th December 2025. Next.
For the petition in this matter, my lord. Here, my lord, petitioner is asking for monetary compensation.
This matter is
My
appealing for
lord.
the first time. All the respondents' cause of action arose at the This is not within the original side, my lord. The respondents and everybody, not even the petitioner, and the cause of action also.
Offices of all the respondents are outside the original side jurisdiction.
Including the petitioner also. And the cause of action.
Let the same order be passed, you mentioned.
Item number 3, my lord, has passed similar order.
The conversion from writ petition on the original side to writ petition on the appellate side. যেটা নিলে সেম অর্ডার করে দিও আর ওই চেঞ্জ অফ অ্যাড্রেসটাও হবে রেসপন্ডেন্ট নাম্বার 1 it is submitted that the address of respondent number 1 has been changed in the mean.
My lord, respondent number 1 address, it has been written outside original side only in this petition, Shaktoria. R.N. Mukherjee Road address was previously there. But
That's
now
why I am recording that it has been changed.
Yes. Officially, it is not there.
Same order.
Deeply with this one.
Item number 5.
Transport Corporation.
Yes, my
For the state law.
my lord, with a innocuous prayer, I am here for your lordship. My lord, may kindly see the prayer portion first. Few documents I have short for.
Yes.
Few documents I have short for from my employer.
A retired employee or working?
Existing.
Existing.
May I just say the facts? My father was an employee. My father retired on medical ground. Compensation appointment was given to me, but I continued with my service, still in service. I have enclosed my appointment letter.
Yes.
I have enclosed my appointment letter where my father's name is reflected.
Your father's name is
reflected. There was a police verification on the basis of the pro forma and the format that has been filled by my father, and my application of my father to give compassionate appointment in my favor on basis of the medical ground. Those documents on the basis of those documents, police verification was made. My Aadhaar card, PAN card, voter card reflects my father's name. All on a sudden, my criminal case was instituted against me by a person who claims to be the daughter of my father, but I am the alone person. I have no legal heirs. Now, 144 proceeding was not 156 clause 3 was filed. I was being arrested. I was put under suspension during the period of arrest. Thereafter,
that lady has to be added as a party.
But no, may I just say?
Why no?
I tell you, lordship, I have only shot for my documents. That is my application that has been made by my father. The pro forma, the police verification report.
So you want return of those documents?
Only a copy, Xerox copy or a certified copy. Kindly see the prayer.
Because original documents are lying with the Transport Corporation.
Yes, with my employer. The police verification report. Prima facie.
So that you can contest the case.
Yes, only yes.
Yes, why you are not supplying it?
My lordship, I need to take instruction
We
from
will
the
come back.
Yes, my lordship.
Because it is stated that petitioner is implicated in a criminal case.
And I was being arrested.
Now those documents are required in order to lead evidence. So therefore, why you are not supplying the Xerox copies?
A certified copy as issued.
Original copies are lying with the Transport Corporation in connection with the employment of the petitioner on compassionate ground. As he is submitted, you take instruction. Issue.
I will, my lordship.
Matter is heard in presence of the learned advocates representing the petitioner, West Bengal Transport Corporation, within bracket hereinafter referred to as state corporation, next close bracket, and the state respondents. Stop. Next paragraph, learned advocate representing the petitioner submits that petitioner is implicated in a criminal case in connection with in connection with which petitioner requires his documents, for example, Aadhaar card and
No, my documents which I have reflected in the prayer portion. That is the police verification report, pro forma, and the letter which has been signed by my father at the time of my seeking my employment.
petitioner requires certain documents. Petitioner ki bollam, in connection with which petitioner requires certain documents, and he has approached said corporation to supply certified copies of those documents. It is also submitted that since certified copies of those documents till date are not supplied to the petitioner, he is compelled to approach this court with the present writ petition. Next paragraph, blind advocate representing said corporation has prayed for accommodation to obtain instructions. Next paragraph, hearing of this matter stands adjourned. List the matter under the same heading for further consideration on Wednesday next, 10th December 2025. Next.
My lordship.
Item number 6.
For the petition in this matter, my lord. Here, my lord, the father was an employee, and my lord, father was, my lord, undergone treatment and found unfit for, my lord, employment. And my lord, subsequently in 2015, the father was, my lord, terminated from the employment on the unfit ground, on the medical ground. Subsequently,
Whether the father was declared medically
incapacitated. They have.
So you want appointment on compassionate ground?
My, if your lordship kindly come straight away at page 28.
What is the order or report relating to physical incapacitation of the father of the petitioner?
My lord, if your lordship, that report they did not disclose, but if your lordship kindly come page 24.
You are representing all the respondents?
I'm for all the respondents.
Yes. Page 24.
Page 24, my lord. You have appeared in the Apex Medical Board such and such at Saktoria for voluntary retirement on medical ground under clause number such and such, and you have been declared unfit for duty as per the report recommendations of the Apex Medical Board communicated such and such, issued by the general manager and subsequent letter such and such. Hence, you are here terminated from your service with effect from 2015 on the basis of result of Apex Medical Board article clause. You are directed to submit your claim for payment of terminal benefits and required documents as per company norms. Thereafter, my lord, the petitioner applied page 25. Next.
Petitioner applied?
Applied. Thereafter, this letter was issued, page 25. Kindly come. They sought for the documents.
Applied for employment.
Employment, and in terms of
your father was an employee.
Now, my
then
lord,
what steps were taken relating to your application
my lord,
seeking employment on compassionate ground?
my lord, thereafter, my lord, if your lordship kindly come page 28.
This is the first application, 27th February 2017.
No.
Page 25.
No, this is subsequent application. First application, based on the first application, they replied in, my lord.
What is the date of your first application?
First application, my lord, really it is not traceable, but they have replied immediately, page 25.
Oh, this is the reply of the Eastern Coalfields Limited in connection with in response to your application. Just to further reference to letter.
Please to submit clarification of the subject between the last date of working and the date of death.
Not necessary.
Yes.
There are page 26, my lord. In 2018, they further wrote a letter from one officer to another. The copy has been served to the petitioner. I have the matriculation certificate. They have accepted, my lord.
Yes, then
thereafter, my lord, my case has been placed before the headquarter for final approval. Page 28. I have downloaded from the official website. Now, my lord, they have discontinued, my lord, this kind of, my lord, display after the several court cases, my lord. Page 28, my lord. Your lords will find from the top. My lord, this is, my lord, they have, my lord,
page
uploaded 28. They uploaded, my lord, the status of employment.
Page 26, then 27, then 33. ফাইল ইন করে কি করে এগুলো? ওকে দেখাও।
Status of employment, NCWA agreement. Her name is
27, then 33.
Oh, my lord. Pagination is there, but it has, my lord, come earlier, my lord.
Documents are there.
Yes, documents are there.
But wrongly paginated.
No, pagination is same, my lord. Pagination is correct, but the 33 has came earlier, my lord. This document, my lord, I want.
status of employment.
Yes, page 28.
28, my lord. My lord, this is, my lord, the employment status. Usually they, my lord, used to, my lord, display. After the several court cases, my lord, they, my lord, discontinued this system, my lord. Now, up to 2023, my lord, they have displayed. If your lordships will find from the top, pending approved at top. Now, and my lord, the bold portion, status of employment under National College Agreement up to 2023.
Remarks under the under
Yes,
remarks.
yes, my lord, remarks. Your lordship will find my name at page.
Against your name is where?
And I am telling, my lord. Where? Mark for us. On page 31, my lord.
Page
31.
Status of employment. See. Page 30.
31. Well, also will find almost in middle WD 6077.
Page 31 at the middle.
At middle, my lord. WD 6077. Let Hiralal Saw.
WB 6077. Yes.
Hiralal.
Yes.
Shah,
Yes.
Name
yes.
of father. You'll also will find
son processed.
Processed.
Yes.
So it is pending, my lord, and processed since, my lord, 2015.
Where from when it is pending?
Since 2015, my lord.
Yes.
My lord, under the normal recruitment process, for age determination, matriculation certificate is taken as base. But in this case, only compassionate employment based on the record available in respect of the father of the candidate. Father
was working in which post?
The father was working here.
He was a trammer.
In place of.
So it can be presumed that he has given wrong date.
My lord, the
You should have given.
problem has come.
You should have given precedence to the matriculation certificate, where it is stated that the date of birth is 87.
But as per service record of the deceased employee, as per his own declaration,
Yes.
age will be more, nearly 3 years more candidate's age. And as per matriculation certificate, his age will be less. And he has been communicated to clarify this position. And this still now this has not been cleared. My lord, he has been communicated, page 26, annexure P4.
Now you don't want to accept his matriculation certificate.
My lord, office record says is differently. Only for that, it is to be first determined what will be the age. Is a peculiar facts, because it is not a general recruitment. If general recruitment is done, then based on matriculation certificate, age is determined. But in official record of the employee, if age is different, in such case, what will be the recorded? On that issue, matter is pending. It has not been decided.
Proceed on the basis of matriculation certificate.
My
What
lord,
is the exact age of the petitioner that can be better ascertained from
3 years differ.
certificate?
Paragraph 11.
Nearly 4 years differ.
Petitioner used to operate trump card within the mine. So it can be perceived that the wrong date was indicated in the service record of the petitioner.
Even
that ought not to be given credit.
even in the both records, if you compare, in both, I am below 35.
My lord, may I pray to file a report so that final decision?
How this will improve your case?
No, I am not
But
telling
thing
the
is this,
approval.
whether
As on date, what is the
Fellowship kindly
stand
come.
of the management? I am not aware in what happened.
Paragraph 11, if fellowships kindly come. Paragraph 11 of the application, if fellowships kindly come.
Just a minute. One is dated 1st of April 1980. One is dated 1st of April 1980.
My lord, I am not aware.
One
What
is
is
dated
the
1st
latest
of,
status?
One is dated 1st of April 1983. Come to page 26.
My lord.
That
even in
when it has been observed that as per service book and PS3 date of birth of the candidate is 1st April 1983. But as per matriculation certificate, date of birth of the candidate is 15 July 1987.
My lord,
So
I am.
you should have given credence to the matriculation certificate instead of what was certified by a Group D employee of your concern, of your organization.
And even if fellowships, my lord, take
My lord,
two dates of birth.
I am not
Even my
aware.
lord, I am below
What is
35
the
years.
Last
In
latest
two
status, I do
date
not
of
know.
birth, if fellowships
Can-
compare, even I am below 35 years. Paragraph 11, if fellowships kindly come.
So
My lord,
yes, there is another point he is placing before this court. Suppose authority proceeds on the premise that date of birth of the petitioner was 1st of April 1983.
Even then I'm 35.
Not 87.
Yes.
As certified or as stated by the employee, father of the petitioner.
Yes, yes.
In that even also he is submitting that he is eligible to get the employment.
Yeah.
So therefore, process his application appropriately. Question could have been different if date of birth of the petitioner, if reckoned 1st of April 1983. In that event, if petitioner was out of contention or petitioner was found to be ineligible in terms of age,
Yes, my lord.
then question would have been different. But the fact is this: if the respondent authority considers date of birth of the petitioner is 1st of April 1983, even then petitioner is within the particular age group.
Right, my lord. My lord,
Why you are not
my lord,
pointing in?
I am praying we may be given 1 week or 2 week time so that latest status position I can get instruction. Only 2 weeks time.
issue.
Or if possible, we may file a report.
Now, obtain an instruction
Ah.
contract based on which and final
Oh,
order is to be
yes, my lord.
Matter relates to appointment of the petitioner on compassionate ground due to death of his father. When father died, where you have stated,
My lord, father not died, he was, my lord, at that time.
oh, since father was declared physically incapacitated
On 15th October 2015. Incapacitated was declared on, my lord, August, but termination was on October.
as per report / recommendation of the Apex Medical Board, capital code, communicated via letter dated 8 October 2015. While processing application of the petitioner seeking appointment on compassionate ground, confusion arose relating to date of birth of the petitioner. As since as per service book of the employee, or as per service book of the father of the petitioner, his date of birth is 1st April 1983, but as per matriculation certificate, date of birth of the petitioner is 15 July 1987. Stop. Next paragraph. Prima facie, it appears, if there is contradiction relating to date of birth of the petitioner based on service record and matriculation certificate, credence should be given on matriculation certificate, or credence should be given to matriculation certificate. Stop. Moreover, it is submitted on behalf of the petitioner that if respondent authority considers date of birth of the petitioner 15 July 1987, in that event also petitioner comes within the zone of consideration in terms of age, in terms of requisite age. Stop. Learned advocate representing Coal India Limited.
I am for the Eastern Coalfield.
Learned advocate representing Eastern Coalfields Limited has prayed for accommodation to obtain instructions. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 17th December 2025.
Can you record his submission that due to that reason, my lord, matter is kept pending? Can you record his submission, my lord, as my lord has submitted?
Whatever I have recorded, it is sufficient.
Item number 7.
Obtain instruction.
My lord.
Item 7.
আচ্ছা একটা লাইন অ্যাড করে দাও। Concerned authority of Eastern Coalfield Limited shall also be at liberty to file a short report.
Yes.
Short report before the next date of hearing.
Grateful.
Yes.
7.
Here, my lord, the father-in-law was an employee. Father-in-law.
Then you are not entitled.
No, I am entitled.
Father-in-law?
Yes. Father-in-law was an employee. I am the widow, daughter-in-law of.
Show me the relevant provision relating to appointment on compassionate ground, because it's the dependent members of the family. Now, what is the definition of family? Let me see.
Here, my lord, I am coming, my lord. Here, my husband applied. During the process, he died. Thereafter, my lord, mother-in-law applied for employment in favor of the daughter-in-law.
Yes.
Now, my lord, this question was, my lord, arose in another matter in single bench, division bench, and Supreme Court. Similar, identical matter. May I place that judgment or, my lord, the provision as well as we desire, my lord? So that has been interpreted by the single bench, division bench, and Supreme Court.
that in that matter which was decided by the Honorable Division Bench, what was the fact?
Same fact, same.
That the
Same fact.
son-in-law has come.
No son-in-law, my lord. Here, my lord, I am the widowed daughter-in-law. Son-in-law is not the entitled. I am not asking for the son-in-law. My husband applied, in process he died. Now his wife is asking for employment.
Now, what is the stand of the respondent?
Stand of the respondent, he is not coming under the zone of, she is not coming under the zone of consideration, so employment cannot be given.
So since she is daughter-in-law.
Daughter-in-law. But
We
my
have
lord,
communicated our decision. In page
on judgment, my lord,
P7.
this division bench judgment will suffice, my lord, my case. Same issue, same identical fact, identical issue. Reported, reported.
কপিটা নিন না
2024 SCC online Calcutta. আমরা একটা আছে তুমি reported লিখে না 2024 SCC online Cal 7.
Against this, no appeal was preferred.
Yes. SLP dismissed, my lord.
Against this straightway appeal, this
is a division
bench order.
A single bench I have also, my lord.
ডিভিশন বেঞ্চ
এটা division bench.
আচ্ছা and how to
In Supreme Court. In Supreme Court.
Then which paragraph it is answered? Fact is at paragraph 4.
Page 4, fact.
Page 4.
No, paragraph 4, my lord.
Paragraph 4 is the fact.
Fact.
Then in which are what are the relevant paragraphs?
Relevant paragraph 12 onwards, my lord, that has been, and ultimately the appeal has been dismissed. 18, my lord.
Just a minute.
Paragraph 17 and 18.
इंस्ट्रक्शन होते हैं আর্গুমেন্টটা কি আছে সেটা না বুঝে কি বলবো
What is the order of the single bench?
Single me order I missed, my lord. I told my junior, but I didn't have copy. না কি মানে মামলা চলছে তখন বললাম ওটা কপি নিয়ে আসবে
Bring that order because there the appeal has been dismissed
my lord.
based on the order of the single bench. Now I want to see the
But
order.
can you make it possible for 5 minutes, my lord? I'm bringing, my lord. So then your lordship, my lord, applied your lordship's mind, my lord. So it's my mistake. Give me 5 minutes time, my lord.
And where is the provisions relating to relevant provisions relating to appointment on compulsion
My lord, it has
under
been
the wage agreement?
yes. A boyta de. A boyta de. Pencil boyta de.
9.3.3.
I'm showing to you.
National Coal Wage Agreement.
ডেট অফ ডেটটা কবে
This is a case of widowed daughter-in-law.
Widowed daughter-in-law.
Widowed daughter.
Yes, ma'am.
Now, who are the other members present in the family?
My mother-in-law. Second category, if LRC is considered, there is second category.
Now, it is provided a dependent for this purpose means the wife, husband, as the case may be, unmarried daughter, son, and legally adopted son. If no such direct dependent is available for employment, rather widowed daughter. So the mother is available.
Mother is available.
Wife of the deceased employee is
Available, but she is not entitled for employment. He is about to age of 60 years. Same fact, my lord.
No, there the issue was son applied for appointment.
Here also same.
And that appointment was approved. But son could not join. Prior to joining, son died.
Here also same.
Then the wife, daughter-in-law of the original employee, and the wife of the son of the employee applied.
Here also same.
No, here son never applied.
Yes, son applied.
Son applied.
Yes, son died, my lord. Before joining, he died. I have annexed the document, my lord.
Just a minute, let me go.
Page 23, my lord.
I thought that son died, predeceased father.
No.
দেখতে হবে তো
এখানে তো বলে দিয়েছে তো এই তো এখানে বলে দিয়েছে
So you have not claimed monetary compensation?
No. Well, also will find, my lord, fact from their rejection. The son applied and, my lord, died in process.
It is only applicable, this agreement is only applicable to the workmen.
My lord. In respect of the officers, there are another.
Non-executive workmen.
No.
Yes, there is a provision for granting appointment to daughter-in-law, widowed daughter-in-law, widowed daughter-in-law. So why you are not granting appointment?
My lord, if
and the issue is decided by the division bench, and your appeal SLP before the Supreme Court failed.
I am not aware of the facts and circumstances of that case. Then I may be permitted to take some time.
Why at the threshold you are not praying for time?
No,
wasting.
my lord,
I am
that judgment
more
under
than
what
45 minutes.
context? Under what context it
At
was?
the threshold you should have prayed for time. No, I am not ready with the matter. Grant me some time. I can understand. Now I am in,
My
I
lord,
have
kindly-
entered into the
kindly
merit
see
of the
the-
case. Now you are praying for time.
My
Is
lord,
it the way?
may I draw your lordship's kind attention to my communication in
You, at the threshold, at the time
Yes,
the
yes,
matter was
yes,
called on, you
38.
could have prayed for time. Now, why after hearing this matter for 25 minutes, you are praying for time?
My lord,
Wasting court's time. You are not a new entrant into this profession. You know how to deal with these cases.
My lord,
Court can grant you time. Court generally grants time, but it has to be prayed at the time of at the threshold, at the first time when the matter is called on. Why after hearing this matter for 25 minutes?
my lord, kindly see page 38, our communication.
What
Page-
does it say?
Page 38, P7. Last para, my lord.
Well, kindly read entire my lord document, my lord.
This is under challenge.
Yes.
Last para, my lord.
Hence it is advised.
Hence it is advised.
Just a minute.
Hence it is advised.
Please wait.
He is reading now. Where is the report?
First to December, instead of second.
তাই তো বলছে, এটাই তো বলছে।
না না কোর্টকে আলাদাভাবে বলতে বুঝাতে হবে।
দাঁড়াও, এখানে তো সবই লেখা আছে, পরিষ্কারই লেখা।
Yes. Now, what is your submission based on page
My lord,
38?
My submission, if direct dependent is available, in that case, the direct dependent can claim employment or compensation as the case may be. And she is the widow. Object of the scheme is when an employee dies while in service, the first and widow will be claimant. That is the practice and procedure. That is the system, my lord. If direct
Come to clause 9.33, 9.3.3.
Single bench, my lord.
my lord.
9.3.3.
দেখো তো আছে কি 9.33? নেই। এখানে তো নেই 9.3।
In case of Arti Murmu also, in case of Arti Murmu, which were against which appeal was preferred, where mother was alive.
Yes. Kindly see the my lord, paragraph 4.
Come to page 9. Clause 9.3.3.
I'm not getting, and এখানে নেই।
Do you have the copy? No.
No.
It is provided therein that a dependent for this purpose means the wife, husband, as the case may be, unmarried daughter, son, or legally adopted son. If no such direct dependent is available for employment, brother, widowed daughter-in-law, son-in-law, residing with the deceased and almost wholly dependent on the earnings of the deceased may be considered to be dependents of the deceased. Therefore, if mother is there, if mother's age is above the prescribed age limit, the question of granting employment to the wife of the deceased employee does not arise.
Right.
So then the right accrues in favor of widowed daughter-in-law.
My lord, employment.
And in similar issues,
If the
in the case of
at
Aarti
the
Murmu,
first hand, my lord.
in case of Aarti Murmu, it has been decided in an identical situation.
My lord, at the first hand, if widow is within the age group, she can claim employment. If she is not the employment age, she can claim MMCC. If widow is available, first benefit will accrue to her. If widow is not available, then second hand, son-in-law, daughter-in-law, it may come. That is the practice, my lord. This is the policy of the company. But direct dependent is alive. Direct dependent widow is alive. Why the benefit will go?
In Aarti Murmu that the mother that her mother-in-law was alive. Because paragraph 14 of Aarti Murmu, so for the judgment delivered by the coordinate bench, it says in the facts and circumstances as aforesaid, the petitioner is entitled to compassionate appointment in ECL.
My lord.
In the event petitioner has surpassed the age of 45 years,
my lord,
she shall be entitled to monthly monetary compensation MCC.
Yes.
MCC.
My lord.
ECL shall take expedite steps to either give compassionate appointment if the petitioner is below 45 years on the date of filing of the writ petition, that is 24th December 2021, or else provide MMCC to the petitioner.
To the petitioner.
So therefore, it is decided in paragraph 14 that the widowed daughter-in-law will get appointment in the event she is 45 years or below 45 years.
My lord.
If she crosses 45 years, then she will get MMCC.
MMCC. Here also.
The same analogy will apply
My lord.
in case of the wife of the deceased employee. If deceased employee is alive, that is the mother-in-law of the present petitioner,
my lord,
then if she is found to be not within the age of 45 years,
my lord,
then MMCC can be extended to the mother.
Now, my lord, if your lordship kindly come.
Then therefore, you have to demonstrate before this court that the wife of deceased employee in case of Aarti Murmu was alive.
My lord, paragraph 4, if your lordship kindly come of the division bench order, my lord. Learned advocate for the appellant.
Paragraph
4. Learned advocate for the appellant further submitted that the
paragraph 4
of the division bench judgment.
That's it.
My lord.
Yes. He was reading the judgment.
Still alive.
Still alive. The learned trial judge ordered directing
Even she, my lord, till date she is alive. I know, my lord, that family.
But in case of direct dependent is alive,
my lord,
then why her right will be surpassed.
Because if she is crossed the age of 45 years, then my lord, she is not entitled for employment.
Then she will get the MMCC.
Because provision is, my lord, kindly see.
That's why in paragraph 14 also the coordinate bench has held.
Coordinate bench held in favor of the Aruti Murmu.
Yes.
Not in favor of.
What is the observation in the facts and circumstances entitled to compensation development ECL? In the event petitioner has surpassed the age of 45 years, she shall be entitled to monthly monetary cash compensation.
Yes.
So therefore, consider a situation. Suppose mother and daughter-in-law, or suppose mother-in-law and daughter-in-law both are alike.
My lord.
Both have crossed 45 years of age.
My lord.
Then who will get the cash compensation?
As per the single bench order, the daughter-in-law will get.
No.
As per the single bench order.
Yes. Yes.
The paragraph 4 is clear answer.
It also struck my mind.
Here, no, the time, given the time that you right is provided, and MNCC view of employment, MNCC can be extended as employment option, just now on your option. And there, my lord, the employment claim of the son-in-law was regretted, and the whole company was rejected. This is wife of the widow of the.
Because her right comes first.
Yes, it may be, she may get it for 4 years or 14 years. It doesn't matter. What is the number of years?
Her right comes first because the direct dependent.
Paragraph 18. Paragraph 18, if your kindly come. Paragraph 18 of the.
Paragraph 14, ultimately it was concluded that the petitioner is entitled to compensation development ECA. In the event petitioner has surpassed the age of 45 years, she shall be entitled to monthly monetary cash compensation MMCC.
My lord.
Why disregarding the claim of mother?
Because paragraph 18, if your kindly come of the division bench order.
No, file your affidavits.
My lord, keeping in mind, ECL has already communicated with the petitioner regarding applying for the MMCC by the letter dated 3rd of January 2023. We have already communicated with the petitioner.
Paragraph 18.
That the direct dependent is entitled to get the monetary compensation.
Paragraph 18, for a moment, kindly see.
No,
Paragraph 18.
Mr. Ghosh, I have a different view.
Page number 38.
Then if there is on this issue, if there is a judgment of the Supreme Court, I am ready to accept, consider this judgment. Not accept, but consider this judgment.
Let the file there.
In a case of compulsory appointment, it's not a vested right.
As per the incident.
And the court has to follow the scheme. Court should not go beyond the scheme.
Well, here scheme has been interpreted by the single bench and division bench, my lord. Followed from the the workman compensation provisions, my lord.
Father-in-law of the petitioner was ex-trammer. যেখানটা বুঝতে পারবেন না জিজ্ঞেস করবেন, হ্যাঁ, অনেক কারেকশন হচ্ছে। ex-trammer TRAMMER of Eastern Coalfields Limited, who died in harness on 18 March 2020. After death of father-in-law or after death of employee, his son applied for employment. Stop. However, son expired on 24th April 2021. Subsequently, petitioner being daughter-in-law of the employee of the deceased employee, daughter-in-law of the deceased employee, made application seeking appointment on compassionate ground. Such application was rejected by the chief manager within bracket personnel close bracket / APM Kenda 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 area on the ground that a wife of the deceased employee is alive and she should make application for monetary compensation. Stop. Next paragraph. Question arises for consideration whether during the lifetime of wife of the deceased employee, right of widowed daughter-in-law accrues for getting employment on compassionate ground when there is specific provision to grant monetary compensation to the wife of the deceased employee in terms of 9.5.0 of National Coal Wage Agreement as full stop deben na, as wife of the deceased employee is direct dependent. Next paragraph. Issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 3 weeks from date. Affidavit in reply thereto, if any, be filed by 1 week after ensuing Christmas vacation. Stop. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. It requires consideration.
Yes. Get back.
Take back your judgments too.
Very well. Yesterday, my lord, I have received, my lord. So my lord, I need some time to file my reply.
File the report, Your Lordship. There was a directive.
Yesterday, it was sub to me after expiry of time. I am not objecting.
There's a direction for filing reply
Yes,
and
yes,
exception.
Yes.
Lordship may permit it to file the report.
देखिए
Lordship, here some of the judgments are also required to be referred from my end, Your Lordship. Those are not with me here.
What is the issue, Mr. Ghosh?
The issue is for, my lord, the getting, my lord, monetary compensation.
MMCC.
My lord. With the widow of the deceased employee, I am praying for monetary compensation from the date of death.
So why this is not being paid under 9.5.0?
I don't know, my lord, why they have not paid.
Lordship, the situation is like this, that there are a series of letters wherein after the petitioner, the deceased employee, actually the employee died in the year 1998. Subsequently, the widow submitted a letter intimating about the death. In 2010, the petitioner, we have sought for the screening and we have also sought for the original documents. Because at the same time, the petitioner herein before Your Lordship in 2010 submitted a letter
voluntary relinquishing her right that she won't take MMCC. She is eager to take employment because she had three sons and two daughters. Subsequently, Your Lordship, we proceeded with the screening, and the situation so arose, Your Lordship, that we sought for the original documents, death certificates. The petitioner couldn't produce any of the original documents. In 2014, the petitioner comes up with a letter addressed to the officer in charge of the police station, Consul Colliery, that the death certificate has been lost. Thereafter, Your Lordship, after a series of time, Your Lordship, we have repeatedly sought. Now the petitioner by this time has becoming overage. So repeatedly we are seeking for the reply whether the petitioner was eager to get a grant MMCC or not, but there was no reply. Now at this juncture, Your Lordship, in 2024, situation has so arose, Your Lordship, we have appointed 3-man committee to ascertain the veracity of the claim. Lordship, there are observations passed by the Honorable Apex Court as well as by the Honorable Division Bench that in these particular cases where there has been an intentional delay and lapses on the part of the petitioner, the grant of MMCC will not be from the date of death. It will be from the 3 years prior to
But
3
why
years.
intentional delay? Petitioner first applied for appointment on compassionate ground, which could not be processed due to failure, due
For
to
want
the
of original
due to the
documents.
fact that petitioner could not produce the relevant documents.
Lordship.
So when it is found that petitioner is overaged, she applied for MMCC.
She never applied. She never applied. That is the crux of the situation here, Your Lordship. She never applied. We on our own, at our behest, Your Lordship, we have taken
There is no provision for family pension.
There's no, this is under NCWA. So this will 9.5 and 9.1.
Then how the petitioner will survive?
Lordship, petitioner will survive. It is the endeavor, it should be the endeavor of the petitioner to come up before the authority. Now, in this particular case, Your Lordship,
I
petitioner.
could understand that there is a provision for pension. Nothing is there.
No, apart from this MMC's NCWA agreements, Your Lordship, petitioner is entitled to get all the terminal benefits. If my lord permits me, I can take the instruction how much.
There is no monthly provision.
No,
Pension.
pension, all the terminal benefits the petitioner is entitled to get. I have to take instruction that affect, Your Lordship, if the petition is getting or not. That I have to, if my lord directs, I can take the instruction.
The petitioner is getting these benefits.
My lord, she has received provident fund, gratuity, all terminal benefits. And my lord, he has
Is there any provision for getting monthly pension?
monthly pension, my lord, very 1,000
Bigger
or something, very bigger amount. But in a case, the husband is my lord, a member of the pension scheme. I don't know whether he was a member of the pension scheme or not. Here, my lord, my medical was conducted way back in 2013. My lord, they processed till 2023. I have annexed, my lord, that chart, my lord, displayed, my lord, from their official website. They, my lord, till date under process since 1998.
The situation is processed simply because.
And now, my lord, the special bench has held. They, in a case of monetary compensation, no application is required to be made. This is their responsibility. This is social security scheme. They have the officers to look into all these things. I have
now proceeded and pay the monetary compensation.
Lordship, we are eager to pay, but not from the date of death.
No, I am asking from the date of death
No,
because
it cannot be,
because
I am guided by some of the observations which my
Very well, my lord.
my lord, my learned friend wants to file a reply.
no, I am also without reply.
Very well, you based on the current monetary compensation you pay and the right of the petitioner to get monetary compensation from the date of death of the employee will be decided on exchange of affidavits.
Lordship, that can be done. Lordship, report I have filed by the way of an affidavit.
May I, my lord, show one judgment of your lordship's court in division bench in respect of the monetary compensation. Your lordship's court will allow monetary compensation with interest.
Lordship,
that will be considered on exchange of affidavits. Let the current monetary compensation from the date of filing of this petition be paid to the petitioner.
Lordship, to that effect, Your Lordship, if in my report also, Your Lordship, I have annexed one letter wherein we have
was filed on 23rd of July 2025.
Lordship,
so you pay it from 23rd
Lordship,
of July.
we are very much eager to pay. The situation is like this. We have made a 3-man committee just to ascertain the veracity of the claim as well as the veracity of the documents as other situations, Your Lordship. If that is processed expeditiously, we are eager to pay from date. MNCC has to be paid.
By fortnight, you release the monetary compensation from the date of filing of this writ petition.
Lordship, fortnight in this particular case may not be possible because, Your Lordship, because it is under process, because 3-man committee has been constituted and the file is under process. So long as the petitioner cooperates with us so expeditiously.
No, what my learned friend is saying, well, page 43, if your lordship kindly come. They process file is pending in headquarters since long.
We are not denying that.
When the employee died?
1998.
From the very beginning, I am, my lord, knocking their door. Kindly see. Page 30.
Within a month, if the 3-man committee's constitution.
Not only that, he died at the hospital of Eastern Coalfield Limited. It is not that they do not know. Now kindly come page 32. This is the
Tell me the date.
Date is, my lord,
11th October.
11th October 1998. Immediately I applied. Then page 32, if your lordships kindly come. Their communication that you deposit all these documents. I have deposited in 2010. Screening of employment was also done in 2011. All the documents I have annexed. Then, my lord, in 2013, they conducted the medical examination and found me fit for employment at 38. Page 38 kindly come. This is a document of 2013. My medical examination was conducted.
Medical examination for what?
For employment.
For employment.
Yes.
So now employment is now not possible since
So time
age is now
surplus.
the MMCC. You have prayed for MMCC.
Yes, I am praying for MMCC from the
This is
date of
for
death.
The current MMCC.
Lordship, for the current MMCC, we are eager to pay. But since there is in the writ petition itself, the last annexure in 2024, there is a 3-man committee has been constituted and we are processing with it. So my lord, give us a reasonable time. 1 month, we will complete the entire process so for long as the petitioner cooperates with us with all the documents. Because the situation so arises, your lordship, we are very much eager to process with the files, but the petitioners also doesn't have the relevant documents. In this particular case, it is not the denial situation that we have not processed with the claim. We tried repeatedly. The records will speak in the report also. We have annexed some of the documents wherefrom it will be very much evident
Page
that
46.
it
Kindly come on page
is
46.
very much evident that we proceeded with the claim and repeatedly we have sought that since you are overage.
What are the documents required?
Or lordship, in my report only, I have annexed those
Please
letters.
tell me what are the documents.
Original death certificate, which she couldn't produce because that has been lost. And other documents, your lordship, these are the letters.
It is a date in Harness case. Then how the pension case was processed?
Lordship, these are our old cases, your lordship.
How pension case was processed?
Lordship, these are our
How
old
provident fund gratuity was paid?
Lordship,
Is there any confusion relating to death of the husband of the husband of the petitioner?
Lordship, there is no confusion. The situation is like this, your lordship. If my lord comes to the letters, your lordship.
You are saying that the death certificate was not submitted.
Not only the death
If the
certificate.
death certificate, please confine your submission at present so far death certificate is concerned. So if death certificate is not submitted, then how the pension case of the petitioner was processed and how petitioner was paid terminal benefits?
Lordship, the employee died in 1998. Subsequently, all the process was made. Now, if my lord comes to page 17 of my report.
Matter is heard in presence of the learned advocates representing the petitioner and Eastern Coalfields Limited. Eastern Coalfields Limited. Stop. By presenting this writ petition, petitioner being the widow of deceased employee has prayed for a direction to release. Full form is
monthly
monetary cash compensation. কি বললাম সেন্টেন্সটা বলো তো বাই হ্যাঁ বাই monthly monetary cash compensation within bracket for short MMCC close bracket.
The question of dependence is also
Stop.
uncertain.
Husband of the petitioner died on 11th October 1998 and prayer is made in this writ petition to release money MMCC from the date of the husband of the petitioner or from the date following the date of death of the husband of the petitioner. Stop. It is submitted on learned advocate representing the petitioner, learned advocate representing the next paragraph. Learned advocate representing ECL has submitted that a learned advocate representing ECL has opposed the prayer of the petitioner to release MMCC from the date following the date of death of the employee, but in the same breath, it is submitted that steps are being taken for releasing monetary compensation or for releasing MMCC by constituting 3 main committee.
Next with the writ petition only.
Next paragraph. It is submitted that petitioner is required to submit death certificate of his husband, of his late husband, in order to process the claim. Next paragraph. From the submissions made on behalf of the parties, it appears that due to untimely death of husband of the petitioner, retirement dues including family pension have already been released in favor of the petitioner.
Family pension I am not aware. My lord,
Pension.
Death come retirement benefits. Family pension.
Retirement dues have already been released in favor of the petitioners. Have already been released in favor of the petitioner. Stop. Keeping the right of the petitioner to receive MMCC from the date following the date of death of the deceased employee open. Court directs concerned is authority of ECL to release current MCC benefits or to release MMCC benefits from the date of filing of this writ petition by 3 weeks from the date of communication of this order.
Can I mention the date of filing, my lord? Because
date of filing of this writ petition.
That date may kindly be mentioned in.
Giving the
right of the petitioner to receive from the date following the date of death of the upon court directs concerned authorities of ECL.
Upon the হবে না, court directs.
Court directs concerned authorities of ECL to release MMCC benefits from the date of filing of this petition.
That is 23rd July 2025 by 3 weeks from the date of communication of this order.
Lordship, kindly make it 4 weeks, your lordship.
Stop. Right of the petitioner to receive arrear MMCC benefits from the date following the date of death of the deceased, from the date following the date of death of the employee will be decided on exchange of affidavits. Let affidavit in opposition to the petition.
We have filed a report, your lordship. Sir.
Full-fledged affidavit filed. Let affidavit in opposition to this writ petition be filed by 3 weeks from date. Affidavit in reply thereto, if any, be filed by 1 week after ensuing Christmas vacation. Next paragraph. Petitioner shall be at liberty to mention the matter for hearing after the time fixed herein above for exchanging affidavit.
This matter, if you
next paragraph, report filed on behalf of ECL in terms of the previous order is taken on.
Lordship, the process, the scrutinization that we are underway.
Get the current benefit first. Very well. Yes.
Lordship, the scrutinization that we are going underway. Let that be completed also, your lordship, if my lord directs. The scrutinization that we are going underway, your lordship, that may also be completed within 3 weeks, your lordship, if my lord directs.
Completed, paid.
Lordship, that has not been indicated in the letter.
No, I will not direct it. Sorry. Consciously, I have not included it. Yes.
Article 9.
My lordship, I am not respondent. I am read by Mr. Banerjee. He is not today present in the court. Can I create for not today?
Yes.
Praying for not today, my lord.
We are appearing for?
For the ECL.
ECL. Who is appearing for ECL?
Mr. Banerjee.
Banerjee full name?
Mr. Shivshankar Banerjee, sir.
Where is he?
He is in another court, my lord.
Not today. Not today, not today.
Here all the respondents including petitioner.
Let the ECL be represented on the next day. I will consider you. I will consider your submission, Mr. Gotakurat.
Number 10.
Item number 10, I'm appearing for the respondent detail, my lord. It is the same case, the determination and jurisdiction, my lord. Item number 4, like
So to A, what is
3, 4.
Respondent number 1, Eastern Coalfields Limited. ওই আগে যিনি ছিলেন না উনি দুটো ম্যাটার আমি রিট পিটিশনটা অ্যাপিলেট সাইড থেকে অরিজিনাল সাইড থেকে অ্যাপিলেট সাইডে কনভার্ট করতে বলেছি বিকজ দ্য অফিসেস অফ অল দ্য রেসপন্ডেন্টস আর আউটসাইড দ্য জুরিসডিকশন অফ দ্য অরিজিনাল সাইড ওই সেম অর্ডার একটা করে দেবো ওর কাছ থেকে সেম অর্ডার
My lord, I shall wait for the next serial number. Item number 14 also same.
ইয়েস ওয়েট
Item 11.
This is my read petition. This is a prayer for releasing the payment service benefits. Or no service benefits has been released.
When retired?
The husband of the petitioner.
Same thing. All the petition
outside the jurisdiction.
Jurisdiction of the 13 RN Mukherjee Road is there.
Same order.
13 RN Mukherjee Road.
Conversion from original side to appellate side.
But fix a time limit, otherwise they will take unlimited time. Within
yes, next.
Yes, 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 yes.
In item number 12, I expect to appear for the CL. But this is the first time we are appearing, my lord. And last day, my lord, my learned senior, I was not there. Learned senior appeared and my lord, before that he was supposed to submit a judgment.
Let me start there after judgment.
So for the
all are outside the original side jurisdiction.
And he is not raising, my lord, so much.
I am raising this point. I regularly raise this point. Not only in this determination,
I know,
Mr. Ghosh in other determination.
I know.
Same order, conversion.
Mr. Bhatt.
Next.
Item 13.
It will be converted into the writ petition in the on the appellate side, and he will mention with notice to him.
judgment
This is also
Same thing. What you are doing? Do you remember? Do you know Horoshit Chakraborty late?
No, my lord.
He used to do all matters in the original side.
Mr. Bhattacharya also started. Anjan Bhattacharya.
Yes,
I know. All these judgment
and
he
you have followed them.
But no, all judgment he taken from me, my lord. Those who I wanted to cite because I understood my lord knows all these things and my lord in education matter, my lord.
Same conversion from appellate side to original side to appellate side.
Item number 40. Item 15.
Just a minute. 14, let it be placed before me. Let the file be placed before me. 14.
দেওয়া দিল তো দিয়ে দিলাম 14 লেখা আছে তো দেখে নাও
Same order.
14.
Item 15.
15, I am for the petition, my lord. May I file my exception to the report, my lord?
This is not the same issue.
No, this is also issue of my lord, monetary compensation.
Nobody is appearing.
No.
When you have filed it?
Well, I have filed. No, here.
June
my lord-
2025.
Yes, and after exchange of my lord affidavit, this matter, my lord.
This is after exchange of affidavit.
Yes, the report and direction was given, my lord, to appear under the heading court application, my lord. Here also I am praying for, my lord, the compensation.
Copy of notice.
No, here, my lord, the issue is something different. Here, my lord, son has, my lord, already employed.
Nobody appeared for the respondent last occasion too.
But I, my lord,
for the petitioner, your name is there and your juniors' names are there.
I communicated them and
nobody appeared.
But I communicated them and they also served me, my lord, their opposition.
Serve a notice. Since a different bench is there, serve a notice.
They, Very well, my lord.
Issue.
Then my exception be taken on record, my lord.
Where is the report?
Report is, my lord, with me.
But has it been
No,
filed?
original, I don't know, my lord, whether file or not.
Where is the question of exception? If report is not filed, nobody is appearing for the respondents.
They served me because I intimated them as per the directions, my lord, given by earlier.
So report was served upon you?
Yes, that's why, my lord, I have file exception.
Who is appearing?
My lord, Amrita Pandey.
Oh. The serve notice upon her and come back.
My lord. My lord, may I get back copy? Or my lord,
Take it back, take it back, take it back. At a time of call, no one appears for the respondents and no accommodation is paid for. Next paragraph, learned advocate representing the petitioner is directed to serve notice, including copy of this order upon the respondents or the learned advocate representing the respondents by 8 December 2025 and file further affidavit of service on the next day. List the matter for further consideration under the same heading on 17 December 2025. Come back on 17th.
Lord, I am appearing for the petitioner.
16.
No one appearing for the respondent. It's against the Red Cross Society.
Third notice, whether any order was passed to you?
No. This is the first time it is appearing.
So, on 24 June 2025
Yes,
filing,
I've
you have
seen
to
it.
serve
This
notice
is the
about
first
the other
time.
side.
Yeah. Again, I'll have to give notice to him.
Yes.
Hmm.
At the time of call, no one appears for the respondents and no accommodation is paid for. It's Article 12 authority.
Yes, Vinod, I
Red Cross
got a
Society.
two division bench decision of the other court also. They have concluded that the 226 lives.
So you will be confronted with the preliminary point of
I know.
non-deliverability of
That's why I know that the first question will come up from your lordship. That point.
That's why nobody is appearing also on behalf
No,
of Red Cross.
that's a different issue. They may say so, but the only thing my claim is that retirement benefit be dispersed. Nothing more than that. Only thing.
Stop. Next, by learned advocate for the petitioners is directed to serve notice, enclosing copy of this order upon the respondents or the learned advocate representing the respondents by 7 days from date and file affidavit of service. Further affidavit of service on the next date. List the matter under the same heading for further consideration on January 2026. Next.
Note 17. If your lordship can see your lordship's last order, my lord. Yeah, my lord, direction was given to file, my lord, affidavit, but till late it has not been filed. Cover excellent chasing.
Due to change of determination, sub notice among the learned advocate. Issue. At the time of call, no one appears for the respondents and no accommodation is paid for. Learned advocate for the petitioner is directed to serve notice upon the respondents or the learned advocate representing the respondents by 7 days from date and file affidavit of service on the next date. Or no, serve notice of the respondent, learned advocate representing the respondents by 7 days from date. Stop. List the matter under the same heading for further consideration. On 7th January 2026. Once it is hard, let me
know. Item number 18. Here.
On behalf of the Eastern Coalfield Malad. Malad, there was a direction to make the payments to the petitioner Malad. He had made the payment. The breakup have not been filed till date. The compliance will be filed, my lord. I can submit a copy to that.
So your grievance stands redressed.
No, some amount has been kept withheld and interest.
My lord, the illegal occupation of the quarter after the superannuation for a long period of time that was being kept, my lord. And thereafter, by the intervention of the Honorable Court, my lord, the quarter was being released and thereafter handed over to us, my lord. There were twice the inventory was.
Just. So adjusting 3,05,120 you have paid.
Yes, ma'am.
So now it is to be decided whether you can adjust it or not.
Annual interest on the delayed
Well,
payment.
that was.
Where is the report disclosing?
My lord, I'll come out with the report because we could not find up the report because the concerned person was being transferred to some other colliery and the new person has come up.
How much amount has been paid?
My lord, 5,39,000. I gave the entire sheet, my lord. I have the one copy. 5,39,000, some amount more, 900.
5,38,982.
Yes, sir.
And what is this 2,90,000?
That is some other amount, my lord. To some other it was been paid.
Not relating
Not
to the
to-
petitioner.
And even the transactions are being disclosed, my lord, on 20th October 2020.
After adjustment of 3 lakhs and odd, this 5,38,982 has
Yes,
been
my
paid.
lord. Yes, my lord.
We really file a report in terms
Yes,
of this order. Client advocate representing ECL, Eastern Coalfields Limited, has submitted that pursuant to the order dated 28 August 2025, adjusting rupees 305,120, rupees, rupees 538,982.03, 538,982.03 was paid to the petitioner. When?
That is there, man. 20th October 2025.
On 20th October 2025.
Detail of the transaction is there, man.
20th October 2025. Stop. However, learned advocate for the respondents has prayed for extension of time to file report in terms of the order dated 28 August 2025 passed by a coordinate bench. Stop. Time to file report stands extended by fortnight from date. Stop. List the matter under the same heading for further consideration on 7th January 2026.
My lord, what the direction was there, we paid it. What was the direction of the
But
last?
the direction is also there to file a report.
That was there, my lord.
That you cannot evade.
No, that cannot be evaded, my lord.
একটা লাইন অ্যাড করো তার নিচে ডিফারেন্ট প্যারাগ্রাফে সবকটা প্যারাগ্রাফে নাম্বারিং করে করে দেবে আমি তাই করি আচ্ছা নেক্সট প্যারাগ্রাফ documents as copies of documents are or documents are filed in support of making payment to the petitioner in terms of the order dated 28 August 2025 and same are taken up.
Offline, my lord.
Next.
Note 19.
But I beg to appear on behalf of the petition.
I'm for the Transport Corporation, madam.
There are 12 writ petitioners, identically situated, aggrieved by the inaction of the respondent corporation.
Inaction relating to what?
Grant of career advancement scheme. I tell your lordship in very nutshell, if your lordship opens the file. But they were all appointed in the year 2010, some in 2010 and majority in 2011. A chart has been given in page 12.
Have you deposited a deficit?
Yes. Full court fee I have given, or for all the 12 persons at the time of filing.
Who is appearing for the state?
But I have served because I have filed the
Old
affidavit.
service, 17 June 2025 filing.
Because I had to file the affidavit of service at the time of filing. Without the affidavit of service, it is no.
Yes.
That,
You have to serve
I mean,
appraise. State presence is necessary.
May I will serve.
Serve and come back. There is no need of hearing you today.
But the only
There
thing
is no need to hear you today in absence of representation on behalf of the state.
This cannot be decided without calling for affidavit. I tell your lordship.
So let it be heard in presence of the learned advocate representing the state. At the time of call, state respondents are not represented. Next paragraph, learned advocate representing the petitioner is directed to serve notice upon state respondents or the learned advocate representing the state respondents, enclosing copy of this order by December 2025. List the matter under the same heading for further consideration on 10 December 2025.
Grateful, my lordship.
Note 20.
Well, item number 20, I am for the petitioner. But today itself, my lord, report in the form of affidavit has been given to me, just today. Kindly grant me a week's time. Let me peruse the report. Well, I come back on next Wednesday.
My lordship, as per the last order,
If
today I have to
if
submit
required,
the report.
if required, I will be seeking for filing an taking an exception. If not required, my lord, I will be arguing before lordship.
আচ্ছা হ্যাঁ অবশ্যই
এটারই affidavit দিব?
এটা মনে হয় না একটাই কপি আছে পেয়েছি
State has not filed anything. It's a question of leave, granting leave.
Yes. Well, since the report in the form of an affidavit has been given only today, well, let me peruse the report. If required, I will take an exception. If not, I will argue before lordship.
Issue. A report in the form of affidavit is filed today on behalf of State Transport Corporation.
Yes.
On behalf of West Bengal, on behalf of West Bengal Transport Corporation, state ta hobe na. West Bengal Transport Corporation. And same is taken on record. You don't want to file any pleading. Learned advocate representing the state respondents submits that state respondents are not willing to file any report or affidavit in this matter. No. What at this stage? I will record it. If you do not file it, I will record it. There is no midway or any other. I do not know whether you want to file it or not. Tell me.
At the present junction, we are not instructed to. At the present junction, we are.
Very well, then I will record it. Do কি বললাম সেটা? Stop. Learned advocate representing the petitioner has prayed for extension of time to file affidavit taking exception to the report filed on behalf of West Bengal Transport Corporation. Let such affidavit taking exception be filed by fortnight from date. Stop. List the matter under the heading hearing in the monthly combined list of January 2026.
I'm grateful, my lord.
Item 21.
Well, I have further petition in this matter, my lord. Will also kindly see the last order, my lord.
18 September 2025.
ED number কত ছিল এটা?
Yes.
Yes.
No response from the petitioner.
No.
This is recorded.
No. If your lordship kindly see subsequent
communicated the petitioner as to requirement of certain further documents.
No.
But till date, no response has been received
Well,
by the coal company.
I have deposited all documents. If you also kindly come page 36. Page 36. This is the employment status under the NCWA. They displaced.
What you are praying for?
Praying for employment because my mother was an employee, become unfit. And my lord, my screening, medical, I found fit for employment, everything. And still then, my lord, if your lordship kindly come, page 68. It is, my lord, shown as processed since 2015. And after deposition of documents, only, my lord, they sent the file in headquarters.
No, where is the communication?
On
which is
page
recorded
6.
in the order dated 18 September 2025, dated 11 September 2018.
Well, page 68, if you have to can you come.
Page
68. No, এটা তো নয়। No. This is for another. Sorry, my lord, this is not the document
No,
of
this
it.
is not a communication, it's a list.
No, list, my lord.
candidates.
In the list, my name has been.
Where is the communication dated 11 September 2018, which is referred to the order dated 18 September 2025?
Communication. কি চাইছে? কি document চাইছেন?
Copy of the said communication dated 11 September 2018.
Well, after depositions of everything, well, they conducted medical.
Where is the communication? You are directed to obtain instruction relating to such communication.
Well, then give me 1 day time, my lord. কোন চিঠিটা আমি বুঝতেই পারছি না।
Do you have the copy of the order dated 18 September 2025?
Yes.
Show him the order.
Show him the order.
18 September
I have seen, can you make it one? No.
Please see the order, because court specifically directed you to obtain instructions.
Yes, my lord. After that, my lord, they processed. So automatically I have deposited everything. So
I want to see this letter.
This is 2018. After that, 2023, my lord, they processed.
This is the order of this court. Court
Very
wants
well, my
to
lord.
see this communication.
Very well, my lord. Kindly give me 1 day time, my lord.
Not today.
চিঠির কপিটা একটা দিন তোমাকে একবার।
Item 22.
Other side. Daughter is asking for, my lord, the.
Yes.
Daughter is asking for, my lord, the.
Other side.
I sub, my lord.
Sub notice come back. At the time of call, no one appears for the respondents and no one appears for the respondents. Stop. Learned advocate for the petitioner is directed to serve notice upon the learned advocates. Or learned advocate representing the petitioner is directed to serve notice upon the respondents or the learned advocates representing the respondents, enclosing copy of this order by 7 days from date, and file further affidavit of service on the next date. List the matter under the same heading for further consideration on 17th December 2025.
Item 23.
By 23, I am for the petitioner.
And I pay for the Calcutta State Transport.
But there are several petitioners before your lordship. My lord, 3 writ petitions have been filed, analogous, identically situated. My lord,
Who is for the state?
CSTC.
But I have served, my lord.
Serve another notice and come.
Very well.
বাকিগুলো কি CSTC পাবে?
Because 2nd May 2025 filing, serve another notice and come.
My
Issue.
বাকিগুলো তো CSTC পার্টি আছে।
At the time of call, no one represents state respondents. However, Calcutta Transport, however, West Bengal Transport Corporation is represented by
No.
Mr. Bihani Lan. Yes, by Mr. Bihani Lan, senior advocate. Respondent 2. Stop. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon state respondents or the learned advocate representing those respondents, enclosing copy of this order by 7 days from date. Stop. List the matter. Affidavit service দেবে না. List the matter under the same heading for further consideration on
company
17th December 20.
Only one thing, though officially, my lord, CSTC has not yet possibly become West Bengal Transport. Lord, she will not say that I'm representing respondent number 2.
They have added West Bengal Transport Corporation. That's why I am.
I know, but
Next day you will raise this issue.
I'll assert it. তবে রাখলো 17 তুই নাম দুটো নিয়ে নে থেকে এই তো
Then the cost title has to be amended in that event.
I'll inform you, Lord.
My CTC, CSTC, and WBSTC,
I know.
they have been combined to form West Bengal
That
Transport Corporation.
notification has come, but
Because-
possibly not effective.
Because the managing director of the 3 organization is the same.
Correct. We'll inform you, Lord. The number zero then.
Note 24.
For the petitioner, my lord.
No previous order.
No, first time, my lord. Can I make it not today, my lord? I will intimate, my lord. Or my lord, password.
Conversion.
Let them, my lord, raise the issue. Kindly.
Conversion.
My lord, I assure to your lordship,
In those matters
new matters,
where
new
orders
matters,
have been passed substantially, I am entertaining, knowing fully well
my lord.
that this.
That I understood, my lord.
Yes. But in this matter, since no order is passed, let it be called.
My lord, new matters I will not file. my lord.
Conversion order টা দিয়ে দেবে।
Note 25.
Here, my lord, there was a direction.
There was a direction to on 18th of September. I am beyond the time. I have received the instruction.
Direction for filing report.
In the form of I have got the instruction of my client ECL. Just 7 days time on next Wednesday, Lordship keeps it. Lordship takes these matter on Wednesday.
Where is the order?
18th
Yes,
of
this order is
September,
there.
18th, I had raised the maintainability point, and the court asked me to.
Point of maintainability is raised.
Maintainability not in respect of this issue.
No,
Maintainability.
that I understand regarding other issue, not on
Yes.
jurisdiction issue.
No, that was in fact that was on the jurisdiction issue only.
No, no.
I raised that maintainability point on the ground that this court cannot be the first forum to raise an issue of employment under that code. That was because they are seeking.
What was your submission?
Because they are seeking job and life interest both. So I raised the issue that whether the question of job or employment can be agitated for the first time before this court. When there is a forum for this kind of decision.
Which forum?
But there are two forums. One is the labor court, and the other is the CAT, Central Administrative Tribunal, who are deciding these issues. Who is deciding?
Central Administrative Tribunal. You have to show me the notification under section 14(3).
Yes, but I that day when
Where is the notification?
There is, as on this date there is no notification.
So therefore,
As on
with regard to the recruitment of a candidate in Eastern Coalfields Limited, Administrative Tribunal Act 1985 will not appear in absence of notification or change of schedule.
Yes.
So is there any notification notifying that Coal India Limited should be considered as a other organization?
No. As
Then
on
why you are making this submission?
That day I said that kindly keep this point open. I am looking for it, but I filed the form. If it is in the form of.
No, I will not keep this point open. Unless and until you show me the notice, it's not a question of filing report.
That was the direction of.
Unless until you show me that there is a notification under section 14(2) and 14(3) of the Administrative Tribunal Act 1985, where is the question that matter is to be considered by the tribunal?
They are considering.
Where from you have learnt it?
They are considering. I can show you the order.
That is different thing. You are practicing in High Court.
Yes.
You are here to talk law.
No,
Show me. If wrongly anything is being considered by the tribunal, that is not the issue. You have to satisfy the query of this court that there is due notification issued under section 14(2) and 14(3). Where is such notification?
I don't. That is what I'm saying.
So, don't make any absurd submission.
No, I am not. I have not made. Since Lordship asked me what was the point, I have just indicated.
That's why I have asked you to ascertain that what sort of point was taken on previous occasion.
As on that date also, I said I am not. I could not get that notification. Kindly keep this point open.
Have you read section 14 and section 15?
When I was moving it.
What is the provision under section 14 and 15?
I will again not place. Kindly will not give me. Internet. There is a.
Go read it and come back next week.
And the time kindly be extended. I will find.
Not today. It's very easy to raise the point of without knowing the law.
I will not try to assist your lordship on that.
No, you are appearing for ECL and you are taking this point in absence of notification under section 14(2) and 14(3) of the Tribunal Act.
This court, those orders are being challenged here and are being upheld by this court. I will place those orders. I was also surprised. I told on that day, my senior friend probably was not there. I said that I.
What report is to be filed on the point of law?
No, not point of law. On this, kindly see the direction. I have been asked to file an affidavit in the form of a report regarding his prayer.
And I've got the instruction of my client. I was saying
First, you satisfy me that why you have taken this point of maintainability.
that I will try
The
to
writ
satisfy.
petition is at this stage is not maintainable
I will
before
try.
the High Court.
I will try to
It should be
satisfy.
considered as other organization as contemplated under section 14.
I will place those orders. I was carrying today. I thought I only seek extension of that time. I'm not carrying those orders, but I will place of these courts for recent orders.
Come back on next day. Call the next matter.
Grateful. And my lord, if lordship
Article 26.
pleases, I can come back with that affidavit under the direction of this.
No, not at that you can file a report.
Very good. There is a direction.
No further direction is required.
Very good. Grateful.
The series order, kindly make it not today. Madam.
Not today.
4:30. No, next matter.
Grateful.
Very well, not today.